May I please, Your Lordship? Yes. Lordship, I beg to mention item number 36. 36. 36. I want to withdraw it on instruction of my client.
Mr. G. Soma, Learned Counsel. 36.
36. 36.
6 to withdraw this bail application upon instruction. The prayer is allowed. And accordingly, the bail petition stands disposed of upon withdrawal.
Obliged.
She might be to mention item 42, Lordship.
32.
42.
44.
Be taken up
Taken up.
in this week.
Another day you want. Another day.
Another day. 26th, Lordship.
Last day. The case diary will be written on the prayer of the Learned Counsel. Platform. It's the matter on 26/9/2002.
Interim order is there, Lordship.
Interim order shall continue till the next date.
And the
City is already, so you have to dispose it of that thing.
May I plead your lordship? I beg to mention item 53 of today's list, your lordship. Some difficulties today, your lordship. After interim is there, your lordship. Matter may come up after vacation, your lordship.
CD has come. Why not you try this week? Yes. You don't know what is in the CD. You can take one chance this week. 26th. Yeah, same prayer.
Interim to
The
continue.
interim shall continue.
Obligate.
May I please, Your Lordship? Lordship, item number 48,
48.
48 and 49, charge is submitted in both these cases. Number is PRC case number 255.
AB, right?
Yes,
So you want to adjourn it to the, you want to adjourn it? We can also take it up at the time and see the charge sheet. It may be possible to dispose it off also. So would you like to wait? Or should we? You want it another day? No.
pending for appearance on 15/11/2025.
15?
14/11/2025.
Don't worry. Lot of time.
SD,
Yeah.
Learned SD Block.
Okay, no problem. 11, it will reach. So we'll take it up and try to dispose it if necessary. Or adjourn it if necessary.
Yeah, please, Your Lordship, my lord. Lordship, I beg to mention for listing of a bail application, Lordship. Lordship, it was last listed on 27/8/2025 and 3 weeks time has been granted, but till
Not listed.
the matter has not been listed, Lordship.
I think today senior bench is available, so you have to make a mention for that. Yeah, this is some matter.
Much of it.
Lordship, I beg to mention item number 50, Lordship. I'm praying for adjournment today, Lordship.
50 CD available.
Petitioner are on interim, Lordship. Interim order will be continued, Lordship.
Thursday? Thursday or Friday? Friday. CDB written 15, CDB written interim order shall continue. List on 26th. DP.
May I have Lordship? Lordship, NCB case, Lordship. Petitioner behind the bars, Lordship, more than 3 years, Lordship. He was arrested on 2/6/22, Lordship. Commercial content, LCR may be called for from the special judge, Lordship.
You have called for the LCR.
Yes, Lordship.
Oh, it's a new.
Already 3 witness examined, Lordship, out of 13 numbers of witness.
So we can go for the,
Respondent, Your Lordships.
we can call for case there,
Sorry.
charge sheet and depositions.
Yes, Lordship.
That will be fine.
Yes, Lordship.
We can for the petitioner and your good name,
PU Pathé.
PU by the Learned Counsel hearing for the prosecution / NCB. So the accused is stated to be in judicial custody since 2/6/2022 in connection with NDPS in connection with NCB crime number 14 of 22. Presently pending before Learned Special Judge Romia
Yes, Lordship.
as NDPS case number 34 of 20. Case is stated to be at the stage of trial. So also scan copy of the case diary, charge sheet and deposition. From the learned portfolio. List on service date from your side if you want.
Your lordship, any date after the vacation?
Yes, it will be after vacation. Yeah, so. It's not. Yeah. So 14 or 15?
14 leave note.
14, 10.
Like,
Regular bail application to petitioners behind about for last 155 days. I'll have a look at the FIR for a moment, Lordship.
Just a minute.
Page 6 in the.
Poxo,
Yes, Lordship. Well, I'll see the FIR, Lordship, whether Proxy, 11 is the husband, Lordships.
just a minute.
Yes. Page 6 is the FIR.
Yeah, he was arrested on
Well, 20 April, Lordship.
this month, this year.
20 April, Lordship. 20
This,
Yes,
this-
yes,
This year.
yes. 155 days, Lordship. And FIR lost by the Gavura, Lordship, against the husband, Lordship.
Husband,
Lordships.
well, let us inform them.
Oh. Well, it's page 30 is the, my lord, victims examination, Lordship. Page 30, Lordship.
I will see it, but in any case, I think we need the,
Page 30 kindly, see, Lordship. Best victim already examined her statement, Lordship.
examine.
Yes,
Like
Lordship. Page 30, Lordship. Now they are having one file also, Lordship.
Yeah. We have to just do the procedure. Issue notice to the informant. She will appear
Former is
on-
the Gavura appointed by the GOP, Lordships. So my Lord may appear, Lordships, on behalf of him.
At least stays to without. I understand the situation.
Yes, Lordship. Having the minor child, Lordships. The victim, Lordship, no one is there to put to look at her, Lordships. So my lord,
Mother is there, but anyway, so. Learned Counsel, your good name?
M. Hoppe.
Tam Hope Learned Counsel. Was drawn my attention to the FIR as well as the deposition of the alleged victim girl recorded in this case. Mr. Call for scans, scan case there, charge sheet and depositions till now of special POXO case number 54 of 25. Under so and so section. Arising out of Dolgaon PS case number 8 of 2022. See, even if someone marries, technically it may be POXO.
Yes.
So we have to follow that procedure. Right? Then we can take a liberal view if necessary. No. So the petitioners shall take steps for issuance of notice among Wahid Mondal, the informant, to take the steps. List after the petition on 14/10.
But NDPS.
That's it. It's good. Yes, please.
May I please, Your Lordship? This is a regular bail petition under section 483 of the NSS. Yeah. Here it is.
It is not charge sheeted, right? Investigation is going.
Investigation.
Okay, your good name, Mr.
80 sure.
Sorry, assisted by S. Das, Learned Counsel for the accused, taking bail in connection with robbery PS case number 300 of 25, section 22C NDPS Act. The accused is stated to have been arrested on 27,000. Call for the case there in the concerned police station. List on when you want
15, Lordship.
15, 10,000.
I'll
It is the lordship. Not 483 application, the petitioner is behind the bar for last 51 days. He was arrested and forward to judicial custody on 12 May 2025, my lord.
12/8.
Yes, my lord, 12 May 2025. For alleged recovery of my lord 5.56 grams of heroin from another person called Shahidul Islam, who is not before the lordship. And lordship, I was 5.56 gram.
That is slightly above the
Slight,
no,
small quantity.
5 grams intermediate.
5 is my lord small.
No, it's less than 5. Whatever is given, this is a catch in the NDPS quantity of law. But as far we can see it later. You that central government notification which is there, right?
Yes, ma'am.
That has to. This is confusing actually. It should not be like this, but that is the way it is. That notification, it lists quantities, right? 5 gram in heroin, 5 gram, 250 gram.
Yes, ma'am.
Right. So that 5 gram is mentioned as small quantity.
And
But
even-
you have to read it with section 2 of the NDPS.
Yes.
Some Roman something.
Yes, ma'am.
Where it is written that quantity less than this, less than the one thing mentioned in the notification will be small quantity. Less.
Up to 5 gram is small quantity.
No, less than 5. NDPS section.
Yes,
Because this is a common
section 2 is
confusion.
there, my lord.
NDPS.
Definition part is.
I will just show you. Okay, that's it. Because actually it's not necessary now here. Your quantity is prima facie, it is intermediate quantity. But just for, you kindly come to
Section 2, subsection Roman, my lord, 33A, small quantity.
33A.
Yes, ma'am.
No.
Instead of the quantity specified in the
Definitions, just a minute. Yes,
possible.
23A.
Yes, yes, ma'am. Small quantity in relation to narcotic drugs and psychotropic substances means any quantity lesser than the quantity specified by the central government by notification in official gazette.
This, the catch. Less than the quantity notified in the notification is small quantity. And similarly, above.
It's in intermediate paragraph.
No, no,
Because
above
it's
that-
5.56 here, ma'am.
So that's, if we look at the notification, that anybody will think that 5 gram is small quantity,
5 grams.
but it has to be read with this, where it says that
Lesser.
less. Anyway,
My 41 days in custody, my lord, and nothing has been recovered, lordship. In a fire also, my lord. It was recovered from a bike, my lord. And I was just standing nearby, so my lord, on suspicion, I was also taken into custody, my lord. This stage, my lord, is my humble prayer before the lordship is to consider the detention period, and also, my lord, that nothing has been recovered from the custody of the present petitioner.
your good name, please.
MH also.
M.A. Chaudhary, London Council Program, accused. Seeking bail in connection with Dharam 2 PS case number 39 of 24 under section of the NDPS Act. The alleged quantity of contraband slash alleged quantity of suspected contraband slash heroin. Prima facie falls in the bracket of intermediate quantity. The accused is stated to have been arrested on
Suspicion, 8 to
11/8/2025 and first remanded on 12/8/2000. Call for the case there, the sub police station. The list on
before vacation, my lord, kindly.
before vacation.
26th day. 26th night.
25th, let
From to 6/9.
Made, please, your lordship. Lordship, this is a regular bail application, lordship, charge sheeted case, the case, LCR may be called for, lordship. Nowadays, TCR, lordship, that may be called for, lordship.
Or still be children and it council. We got a position. Call for the, this will be, it is charge sheeted, right?
Yes, Judge.
NDPS commercial.
Commercial.
Call for scan copy of case diary, charge sheet, case diary and charge sheet. It has not started, evidence has not started.
That is.
NDPS case not registered, right? It is, charge has not been framed.
Charges not being paid.
So in that case, this will be case diary and charge sheet, scan copy of case diary and charge sheet. This will be sufficient. The accused was arrested on 28/4/2020. List on 24/10. 24/10, okay. 24/10/2025.
Highly evidence.
Lordship is second time application, Lordship. Yeah, impugn order is at page 26, Lordship.
Rejected on 9th. Right?
Lordship.
That's injection, that's a alleged. Injection. As in, we have this co-accused bail, I think, last working day, we had taken up and fixed on some dates. What is this case?
Tomorrow is get fixed.
It's fixed tomorrow. Happygaon PS 126.
Lordship, tomorrow is fixed.
Is it Roma? Now this comes first. This is the subsequent bail application. So all for the updated case diary of Happygaon PS case number 126 of 25 under section 12. List on 23/9/2025 along with you.
PA number 2892 of 2025.
2892 of 2025. 2892.
Of like.
Thirty-five days behind the bar. Therefore, in page 17, my lord, the allegation is that they have stored some diesel, my lord, in their house, one godown owned by the Sapondas. He has let out this godown. And other accused person, they are purchasing from the local petrol pump, they suspected this high-speed diesel, and they sell it in the remote areas for running the machine, my lord. So, well, 35 days, all this diesel has been-
Violates the essential commodity.
only essential way, but the other section of the given the gang organized crime, it will not come up. As an essential commodity is a bailable offense, but 35 days already behind. And the suspected diesel has been already seized. Probably nothing remains to be investigated.
11/3, 11/4.
These are organized crime, but it is not an organized crime. But
Yes, here the 600, it reflects the organized racket of selling in by.
that is the order by the last court below. That's why we have come before the Honorable High Court.
Is our 17?
Is a page 17, madam. This is what I have submitted, madam. It is reflected in the FIR. Stored in the drums and gallons along with the motor pump. Furthermore, one oil tanker bearing registered on such and such high speed was the owner of the godown named Shopandas, and such other persons were present and they were arrested. It is not a stolen goods, madam. We cannot steal it from the petrol pump. But
Right.
it is fact they are storing it and selling it in the rural areas without the authority. That's why essential commodities act.
Which is bailable.
Yes.
Not only whether 1,000 drums and gallons for high speed diesel.
And it is
Along with one motor pump that is to Z pump. In presence of the Z pump, thereafter several numbers of empty drums and gallons were recovered.
accordingly seized in presence of Miller.
I submitted to a-
Oil tanker bearing this.
All these in the oil, in the godown.
Located with suspected SSP or inside the premises. That oil tanker was found inside the premises. Was
Anyway,
accessible.
we call for the case there.
Yes.
We wait for you if it's after vacation.
Still chairman. But considering the Essential Commodities Act, your lordship can grant it. madam. Other sections are not applicable at all. If he convict, he will be convicted under the 7 of the Essential Commodities.
Earlier bail rejection order is also.
Act. That I meant to enforce.
Turn it for pillow.
Yes.
Necessary to see the case direction. So I think so. Can you bring it on 26th? Kasa.
Okay.
Let's see, Business Learning Council, we got the sheets. Call for the case there, yo. Chilchur PS case number 842 of the That's which. Accused was arrested on 28. All the 3 accused persons are arrested on 28, 20. In fact, list on 26/9. Let's take a chance. 26.
Associated case.
Procedural lordship. Lordship 483 application lordship. Petitioner was arrested on 34/2025. Today is about 144 days. In this case, what happened, lordship charge sheet submitted and the informant is lordship doctor. Doctor. So my lord, in this case already the victim, she has been examined lordship as a PW1. I have annexed the copy lordship. There is a love affair between the petitioner and the victim lordship, and they are ready to get married lordship. And the affidavit they see shown if the bail granted, she has no objection because they are going to start their conjugal life after release of. There is no force at all, lordship. She has stated, lordship is mentioned. So, lordship, as the doctor is the office on, she has lost the effort on behalf of the office, lordship. That is why, lordship, if we can represent her, lordship.
Don't know about that. Can you represent?
Yes, lordship, because she has, no, lordship, in this case, what happened, doctor, she has no, she is the
Official.
official lordship,
Official
that is what. So, official informed. And the victim shown an affidavit at page number 28, the relevant person has 29.
Anyway, can you locate her? Because the doctors keep moving. He was on the.
Because-
Oh, she may be in the, sir, 25 case. Can take an instruction. Yes, and.
Victim, she is not party here. And she has,
Informant representing the victim, in essence. In essence.
Yes.
What is our case law says? Our High Court. case-
lordship, yeah, the High Court, order passed by the Honorable Supreme Court and High Court, lordship. Notice should go to the,
Let the notice may go to the father of the victim. my lord.
As well as to informant.
Yes. Yes, as well as today. If father of the victim, my lord, it says that.
then can it be on 20, it is from Guwahati, lordship, can be 25 or 26 like that.
25 is very blocked.
26,
It's been argued standard council. The accused is stated to be in jail since 34/2025 in connection with special POCSO case number 98 of 25 arising out of Polkan Budar case number 546 of 2022. My attention has been drawn to the deposition of the deposition of the victim, as well as an affidavit of no objection purportedly made by him. Looking at it from both sides, I think because will it be victim is a minor?
no, right now she is major minor.
Also, it's
She has attended the major. Notice to,
issue notice upon the respondent number 1. Dr. Pinky Majumdar was the informant. So number 2. And also to the father of the victim, father of the alleged victim. We don't know her name.
This is at page 25.
So it will be in the deposition.
Yes. That should be reflected.
But should I reflect the name of the victim in the order?
While she is in touch with them as a victim along with the petitioner, serve copy to the.
No, through the
Later. Oh, yes.
after all,
To the
So the-
victim, we can serve the.
you can serve it.
I will,
It may be,
I will serve
may
it
not,
for the,
may not look proper.
yes, yes.
Get it served.
So police station.
I have understood the case. Get it served. Let us complete the formality.
Lots.
That is it.
Lots.
Issue notice upon the father of the alleged victim. To the concerned police station.
Yes.
Then, my lord, I have to make party to the father of the victim. Otherwise, we cannot take steps. Lordship. You cannot. I will-
Yes, I file an additional affidavit.
No, we can amend that lordship if lordship permit. Or at the party.
Or you can file an I.
It may take time.
Which will be faster. Amending.
If lordship pass the direction, we can directly file the petition.
They also seek and file an
Yes.
additional affidavit. By
Additional.
No, lordship, if additional affidavit we file, it has to come before the court. If it is reflected in the ordership, then we can, if we file, then father's name will be reflected in the.
File a fresh petition.
No.
Correct.
If lordship pass a direction, in this petition, we can file an additional affidavit, lordship.
Additional.
Lordship.
There is no bar in bringing the name of the father on record.
No issue, lordship.
she wants
Because
to.
the
Procedure is
principles
that-
of Nipun Saxena is very wide.
Yes.
Actually, so any kind of identity concealing or privacy of the, anyway, this case is different, but still POXO.
Yes.
Technically POXO.
This is the difficulty.
This completed statutory, 60 days. 60 days offense,
Definitely,
that will be 90 days. 300, let me check this. Over.
187.
No, 310. 310. Section 2. Section. It was 90 days. 90 days.
60 days when investigation relates to any offense of
Yeah, police
10
custody.
up to 10 years.
Police custody.
Yes,
Completed 62 days.
62.
RK Nagar is in which district?
Ramkrishna Nagar. Ramkrishna Nagar station.
Yes, sir.
Karim, Sribhumi.
The accused Tutun Das was arrested on 2025 in connection with RK Nagar PS case number 56 of 25 under section 7. Located in the district of Sribhumi. Will we call for the case there? Yes.
But can
It
it
is
be
pointed out that the accused has been in custody since the last 61 days,
60? Today is 60.
62 days, as on today. Call for the case there, the concerned police station. Date is a problem.
This is not, after
After vacation,
Let-
date for
let try
26. 26 night. Because 25 also there will be huge number of matters
much.
which may spill over. I'll try to finish it. Let us go first. 11, 12.
Big lordship. First, my lord, I just want to take a lordship to FIR, which is on page 15. Lordship got it, man. which is on 15, page number 15, my lord.
Okay.
I'm just reading out the,
I can read through also, or you want to read?
yes, my lord. I'm just reading out the relevant portion for lordship's kind convenience, my lord. To the officer in charge, Chographer Police Station, sir, on 7/8/2025, at around 6:20 a.m., OC Chographer informed me over phone that a person has been apprehended at Chographer Shore and with suspected narcotic substances. Suspected. Accordingly, as verified, Chographer so-and-so that at 7/8/2025 was made, and I proceeded to Chographer Shore with necessary equipments. At Chographer Shore, I saw a person sitting near a bus who is suspected to possess the suspected narcotic substances. Again, my lord, suspected. There I came to know from OC Chographer that a random narco checking was going on since 3 a.m. by a police team comprising so-and-so. During the narco checking, a bus named Sopna bearing registration number AS so-and-so was signaled by the police team to stop. The bus stopped near Chographer traffic point. When the police person started checking the vehicle, a person wearing black pant and maroon colored shirt got down from the bus and ran away. Upon suspicion, the police party seized him and caught near the Chographer fish market. And my lord, the suspected ganja was found to be 10.13 kgs mile. And now, my lord, I just want to take a lordship to forwarding report, which is on page 17, my lord. Doesn't this,
Still on the same day of the incident.
there is no discrepancies. Discrepancies in the sense, my lord. I just want to bring to your lordship's mind details of it. In the FI, it was said that as soon as he was sitting near a bus system, the accused was sitting near a bus system. In the forwarding report, it is not mentioned. That is absent, my lord. And my lord, I moved an application before bail application before the Honorable Special Judge Nalbari. I just want to take a lordship to now page 37, Annex 4. 4/9/2025. This is the order passed by the Honorable Special Judge Nalbari. Only the last portion, mine, page 39. Last paragraph, 30, page 39.
Yes.
Considering the above facts and discussion, and on prima facie appreciation of the material on record, and considering the nature of the offense and bail objection raised by the IO, and the fact that the investigation is yet to be completed, there appears no justifiable ground for releasing the accused or on bail at this stage. As such, my bail was rejected. Only, my lord, the IO raised the bail objection, my lord. This is not a commercial quantity, my lord. 2 bags, there's a 5.3, 5.7, 2 bags, these narcotic substances suspected to be is alleged. So, my lord, I just my lord, I just want to allow me to go on bail subject to your lordship's convenience, my lord. And I can assure your lordship, my lord, if allowed to go on bail, my lord, I can assure your lordship, my lord, your lordship's every order, your lordship's every directions, your lordship's every restriction that will be imposed on me will be followed in letter and spirit, my lord. And in this regard also, my lord, there is a charismatic judgment of the Honorable Supreme Court, my lord. If your lordship allows me to place it, my lord, I can place it. Otherwise,
You can record. Please.
my lord. I'm only 32 years old, my lord. I'm a my lord vendor. I earn my livelihood by selling vegetables and all that, my lord. In my lord, Salvi and Aris was the state of Karnataka and Aris, which was decided on May 5, 2010, my lord. Para 79. It is plausible that investigators could obtain statements from individuals by threatening them with the possibility of administering either of these tests. The person being interrogated could possibly make self-incriminating statements, which is important, my lord. On account of apprehensions that these techniques will extract the throat, such behavior on part of the investigators is more likely to occur when a person being interrogated is unaware of his or her legal rights. My lord, every question that is asked to me by the police, I'm apprehensive. Obviously, my lord, general person will be apprehensive of the police, my lord. But the police, we are sitting at the bus station, my lord, and he was caught. But no substance has been recovered from him, my lord. And section 50 NDPS is not followed, my lord. And in this regard, my lord, the NDPS Act, my lord, I fall in between the intermediate, my lord. The notification is specifying small quantity and the commercial quantity, which your lordship is very much well aware of it, my lord. And which is on serial number 55, ganja, minimum amount of 1,000, maximum 20 kg, which is a commercial quantity, my lord. And I am not involved in the commercial quantity, my lord. Your lordship is very well aware of it. I only pray, my lord, that bail should be granted, my lord. And if bail is granted, my lord, I can absolutely, if any order is flouted by me, if any restrictions on orders is flouted by me, by your lordship's order, then I can be, my bail shall be cancelled and immediately I shall be put to jail, my lord. That's all, my lord.
So it is not that only because IO has objected the bail petition and for that reason trial for this one rejected the bail petition. Well, also, the Caesar witnesses have also stated that 2 bundles of ganja weighing 10.13 kgs were seized from 2 bags, which were in possession of the accused. Also, from the statement of accused, prima facie that appears that material there appears material that accused is involved in trafficking. So on the basis of not only grounds of arrest, Caesar list is also there that from the position of the present accused persons those contraventions recovered in presence of Caesar witnesses. Therefore, considering the statement of the Caesar witnesses ultimately, that bail petition was granted on being after recovering possession those the contraventions from the position of the present accused. So it is not that only because IO has objected because of that.
That's okay, but the only thing is that we'll have to fix it on Grappa base. Because he was arrested on 8. It applicable is 60 days. So it will be over in the middle of the petition. So we'll have to fix on 26.
26, then they are on that day, city not received, then
We'll see.
I will have to fix petition for.
Yeah, there has to be something has to be done. 8, 9, there will be vacation for the moment on Friday.
Friday, my lord, I have got no objection if it is to be, even if it is after puja vacation also, I will have no objection. Because your lordship will be pardoned, my lord, on 26th, your lordship will be pardoned, my lord. There is so many cases.
Thanks for your understanding, but the thing is that on 8th or 9th of October is statutory period will be over.
My
So
lord,
we must take a chance on 26th.
my lord, I am SSA Rahman.
Yes. It's SSA, SS Hatu Rahman. Your Miss Siri?
My lord,
Your junior school?
yes, assisted by my lord.
BH Siri? Yes. That councils was taken the court to the FIR, the relevant documents. And content about the innocence of the accused, as well as some procedural infirmities. Additional accused was arrested on 8/8/2025 in connection with Bhograpar PS case number 76 of 25 under section NDPS Act. Prima facie, the applicable statutory period will be 60 days. I've just written it from
My lord.
the call for the case there list on 26 now.
My lord. Highly obliged, my lord. Obliged, my lord.
Your worship, your worship, the vector.
That doctor, my lord, the worship, and then. So today 50 days, my lord, is already over. 60 days, the statutory period. I'm not on merit now, my lord. Only on that, my lord. And he is having alternative medicine, my lord. That your lordship, they have submitted that he is not allopathic, but that is, he is permitted to allopathic. Surgery part, my lord, that would be looked by the city, my lord, in the trial to come whether he is done or not.
Last rejection was 16.
Yes, my lord.
Should I, what do you propose to do? Can you take a instruction about that, about whether investigation is complete? Yes.
Or my lord, Friday, it may be
Now, yeah, Friday.
Friday.
We'll just call for the case diary. Yes.
Fixed on Friday.
Heard subsequent bail application. Earlier bail petition was rejected on 16/9/25. Call for the case diary of Silchar PS. Okay, the learned PP, so the learned additional PP, so I may also try to take an instruction from the high about whether investigation is complete. List on 26/9.
I'll let you know.
Which is 483 petition also. Because FIR is in page number 10. Also 103 is there also. The CD may be called for also.
The accused heard. No, Mr. SN,
Yes, Lordship. SKSN Mohammed also.
learned counsel clearly submits that notice states CD may be called for. In connection with Anwazar PS case number 259 of 25. Under section so and so, in which the two accused persons hearing were arrested on 9/8/2025. Should I fix it after vacation?
Yes, fix the date, Lordship.
On reopening. 13. 13.
Always, Lordship. Second bill application, Lordship. I have allocated 36 days not in custody and keep it on 25th, not Walpara PS, not.
Style assisted by NDPS. It's fairly submitted that this is the subsequent application. The petitioner is in custody since 16/8. Call for updated case diary open. Which Walpara PS case number 159 of 24, section 12. List on 26.
25 Lordship.
25, actually, I
24 or
can
20,
fix, but we have fixed at 39 matters already. 26. 25 will come down the list, but 25 and 26.
24 also.
We have to sit extra and complete. But 26, only 8 matters have been fixed.
The 26, I have some personal difficulty.
25.
25.
25.
May, I please,
Yes,
Your Lordship, this is subsequent bail application. Only, Lordship might clear that, whether his further custodial detention is required or not. So, Lordship may please to fix it on 25th. Lordship.
26.
Yes.
So, this is fairly submitted that earlier bail petition was rejected on March 15/9/2025. In connection with Cyber PS Guwahati case number 9 of 2025. And the student situation. Call for updated case there. It's on 26/9. Some of these might have been completed.
20.
26. 26,
25 can,
25.
26,
We have fixed a lot of matters. So if you do not have personal difficulty, you can fix it on 26, right?
26. With, no, Lordship, with that instruction, whether further interrogation is
Along with
instruction.
the IO may also should submit or the IO may also indicate along with the case there as to whether his custodial examination might be necessary. Should I?
It's okay, no, it's okay. You also may call for the updated signal.
That would be better. So every case actually we have to mention this as let us find it out yourself. Sometimes they already mention. They automatically mention the bail objection or whatever it is. Only see that.
Apply.
No, Chair.
English class, notice में ऐसे POCSO class होता है.
Notice salvation. You have stopped MJ Bol.
DJ बोलो.
No?
DJ बोलो.
DJ Bol. But DJ Bol and council. He got it. He submitted that. Really submitted that. In a POCSO matter, notice may be issued. It is at the stage of investigation.
Yes,
As
sir.
per your instruction.
Yes, no, sir.
Call for the case diary of Lalu, PS case number 180 of 25. And that's what it's. Oh, it is investigation is completed, it seems. Let us check.
No,
Not sure.
Yes.
Because POCSO.
The POCSO matter, Lordship. Like Lordship, kindly say, I have an annex on medical report, Lordship.
Or not, that may be examined by the police matter. I will appear matter. For the time being matter, I may be protected.
29 also they are so, like a diary.
Yes, daddy may be called for matter. And Lordship may fix for hearing.
At least we took a case, going the case.
I think 37 will be applicable to interim bail also. The thing is that he is not named in the fire. So. Not sure. Because 37 has to be seen. Because we don't know whether he is involved or. Is he connected with the vehicle?
Vehicle, he was the first owner, my lord. He is already sold out. That is
The
page number,
owner.
page number 19. Madam. Page number 19. The agreement matter. By executing this agreement, page number 20 is the valid operative portion, page number 20. And Zahirul Islam is the petitioner sold out to Sharifuddin matter by executing this agreement matter. So he is not totally aware about the vehicle or any other allegation. My lord. Totally innocent. My lord. I will appear, my lord. My statement may be recorded, my lord. Case 22 in the RC matter, in my name, my lord. That was going to be transferred.
I have not gone through the FR in detail. Can you flip through once and tell me, he's not named.
Not name, not name.
Confirmed.
There is no whisper, my lord, about the petition. My lord.
Otherwise, 37 will be applicable. If we have to give bail, interim bail now, then we'll have to say that because of these reasons, 37 applicability of 37 may not come at this time.
Main culprits are arrested.
But I don't know whether that will be correct to say. There may be a situation where case is raised under 30 under commercial quantity, but there is no whisper. There's nothing against the person. Prima facie on the FIR. In that case, applying 37 will also be bit unfair. That is also to think of the situation. Suppose he may not be connected also. Nothing in the FIR, no whisper. But then applying, will it be fair to apply 37?
Vehicle is in the name of.
Vehicle is there. That linkage is
the agreement.
agreement no, to run the vehicle.
Run the vehicle.
But the people running the vehicle can also. They may be only responsible. Owner may not be responsible. May not. It's a matter of investigation.
So wait for a case there, it's acceptable.
But in that case, because I believe this thing also from point of view of everyone. Suppose he has no connection, then he may be arrested. Suppose. Undoubtedly, there may be some link. There may be some, maybe likely. But is there any statement like this in the allegation? Of course, you have said, I fully trust you. Is there anything in the FIR which says that at his behest it is being done? No, nothing.
Nothing.
Only on the vehicle is there absolute owner of the vehicle.
Absolute honor, which he claims to see of soul. 482 but
Yeah, Ali.
and 482 bail application. UNSS, seeking delay case number 47 of 2025, under section 21C 25 of 29 NDPS, read with certificate. The case arose out of fire dated 26/8/2025, logged by a police officer. The gist of the allegation is that one truck, 16-wheeler truck bearing registration number AS02DC 6129, coming from Dimapur side, was checked, and contraband in the form of narcotic drugs was found. So the narcotic drugs / psychotropic substances was found. The case is stated to be at the stage of investigation. The learned counsel submits that there is no, the FIR does not name the present petitioner, and he is the owner of the truck. He admits that he is the owner of the truck, which he has also sold in the meantime. In the meantime, he has already sold. PP Goswami, learned additional PP, submits that at this case, it would be prudent to just call for the case that the learned petitioner counsel prays for interim protection. Next paragraph. Call for the case diary of Delay PS case number 47 of 2025, the section also. With regard to the prayer for interim, I take note of the fact that case is registered under I take note of the fact that the penal provision of 21C pertains to commercial quantity, and therefore, on the face of it, section 37 of the Act would be applicable. Next paragraph. However, it is confirmed by the prosecution that the FIR is not named. The accused petitioner is not the petitioner is not named in the FIR, nor any allegations made against him for transshipping illegal drugs. Therefore, in a situation like this, perhaps it might be unfair to make the rigors of section 37 applicable to him without giving him an opportunity to record his statement before the IO, and also it will be unfair to apply the rigors of 27 without giving an option and without perusing the case there. Therefore, I deem it inclined to allow the petitioner to record his statement. Therefore, it is directed that in the interim, the event of arrest, the petition, he may be allowed to go on bail of 30,000. Subject to the conditions number 1, shall render full cooperation to the investigation, semicolon, he shall appear before the IO and make himself available for examination, semicolon. He shall not indulge in any illegal activities. We list immediately after petition, 13th. But I don't know whether it is fully correct or not, but this is, I'm looking at it from point of view of logic, just pure logic. Someone may not be, maybe innocent. Why apply 37 straight away based on the thing?
Meet me, Your Lordship. I apologize, Your Lordship, for
No,
moving the
sister,
matter, Your
you
Lordship.
can't meet two courts at the same time.
Your Lordship, may kindly peruse page 9. The relevant portion starts at page
13 year lordship. The accused petitioner was arrested with 12.5 grams of heroin. Your lordship, may I read the FIR?
Yeah.
Page 30. With reference to the subject cited above, is to inform you that on 10/8/2025, I was detained for narco checking duty along with staff of Bhadgaon PS, and accordingly during checking at Bhadgaon Curiae, Punjab, a person riding scooty bearing license number so and so tried to break narco checking signal and flee. However, the same person along with the scooty was detained opposite Golden Tower at Bhadgaon. According later detention service group of the same person and also the same scooty. Later during search, suspected urine was found at the person certainly the matter was immediately reported to OC Sargaon PS. Then a GTMP was made by OC Sargaon PS by Sargaon PS unit number 18, 25 in this connection. The agent operation was referred to me by Inspector UB opposite Kakoti, officer in charge of Sargaon PS, who is empowered by Government of Assam by notification of the dispute 15 June 1995 under section 41(2) of NDPS Act to issue such operation is to be noted. The agent operation was sent to me and delivered by UBC 3204 Baltimore Harwell of Sargaon Place. Further, nearby shop owner and security guard of Golden for our apartment was told for and was explained regarding the similar communication letter or message to take it procedure. The name and address of the witness are mentioned below. Later, a notice under section 50 of the NDPS Act was served in the presence of the witness and body was searched on the track vessel in the presence of independence and saying videographs and no CEO's presence was demanded by the NL section. At the time of research and under the management of the claims of the moving items were recovered, the narcotic substance suspected to be loaded up to plastic bags on Honda driver's scooty bill number 1 series. The total weight of the suspected heroin recovered was 12.18 grams and same was only seen along with the scooty and 1 series respectively in the presence of witness and was videographed to each side of F. The C suspect heroin was properly packed and sealed at the heroin recorded in legal procedure. Details of C items suspected heroin recovered was 12.18 grams. So, Your Lordship, in this case, intermediate quantity, but very less, Your Lordship, just above small quantity. And I have to make an admission here to this serious case, Your Lordship, is that this particular person is an unemployed youth and he is an addict, Your Lordship. He took this particular thing for consumption. He is behind the bars for the last 42 days, Your Lordship. In my estimable submission, the preliminary investigation of the case may have been over by now, Your Lordship. So may I pray that the short let me fix
29, sorry, 26. Take a chance. No, actually, it is not marginal quantity, 5 grams.
5 grams.
Then 5 gram and above is intermediate.
Yes, sir. Right there.
Much below the commercial, of course.
Yes.
50,
Yes.
So, the top base case look 146 of the T Deori, system 5. You're good. The accused was arrested on 10/8/2025. Call for the case diary from Interim police station. It's on 26/9. Some should be possible. Friday.
I'm very grateful, Your Lordship.
Then anticipating bail application amongst the alleged section 1316. CB.
Case diary. Along with medical report.
130 is their PM report.
PM also 123. Here, perfect. Your good name.
Miss P.
P. Bora. Learned counsel. Shall submit that is case that in the report of Muragaon case number 49 of 20. The accused was arrested on significant no picture for this reference. Can you help me with this? When was he arrested?
It's an anticipated.
I can't figure out this. The anticipatory bail in connection with this. So when should we?
15, 10. It's an anticipated matter.
No, no, it is not 103.
130 is there.
Will it be okay if I sit after books? Immediately, first day, 13th day.
15.
Huh?
15.
After 15 or on 15?
No, on 15.
15th day.
Yes, for my equation. Yeah, okay.
But learned counsel. And appears on behalf of the informant. You can take a copy of the petition later. Sir.
This item may be fixed on 24th, my lord, along with bail application number 3058 of 2025, arising out of the same
Same
incident.
empire. PM shall be the system, or you choose. Submits that display petition, may be fixed along with, along with
BA, my lord, bail
connect-
application number
connected, BA
3058.
5 of 2024. Which is fixed on 24th. Call for the case diary of the board PS case 97. Fixed on 24.
I'm authorized.
Day after.
Lordship, this matter may be fixed at two lordship. Recently on 16 lordships, 2772, this honorable court was pleased to grant on bail. Lordship may label. So lordship CDs might be on.
After two.
But a petitioner is the owner of the hotel.
What's wrong?
Yes, hotel is run through the manager. He is the owner and he
Oh.
resides at Nalbari. Now, some immoral trafficking is registered been held in the hotel. This person is physically challenged person, but he resides in Nalbari. So he nothing to do with that minor. But the only thing that you kindly see that page 21.
It's the FIR.
Yes, FIR.
I'll read.
Page,
I'll read.
yes.
You'll have to see the case then, sir.
Hello?
You'll have to see the case then.
My lord, only as far as the petitioner is concerned, man. He is the owner, my lord. Your worship, kindly see.
He's the manager.
No. He is the owner, my manager is Sadullah already
For
arrested.
the arrest.
Yes, he was already arrested.
The manager.
Yes, manager. And your worship, kindly see certificate part of page 30. He only for his livelihood, he stays in Nalbari. And this is, and there is a title suit pending between the owner of the land as well as the present petitioner. That also I will show to your worship.
Owner of the land.
Owner of the land. He is the person, my lord. Your lord, there is an agreement for 3 years.
Devojit Bora.
Deposit program.
Devojit Bora is the.
Yeah. Now here you have kindness, my lord, first kindness say page 13, my lord. Right? Just page 3, my lord. Oh, sorry, 1-3. 1-3. Is 60% my lord disability. Locomotor. Your worship got it now. 1-3. Then kindly see my lord, title suit order.
I got it.
Yes. Title suit page 32 years.
Who is Devojit Bora?
The Bajibaka is the owner of the land. Land means for the hotel. I have taken on the rent minor from him. The budget for.
I see.
So your kindly the titles of page 32. Whenever he just hang a notice in my hotel that you are to leave within July. You are to leave the hotel. Agreement is made up to 3 years. Then you will kindly see, then order is, that order dated by the page 42.
I see.
Page 40.
Injunction.
Yes, madam, injunction. This is the reason why, my lord, I have the police also done. I am not named in the FIR.
You're not named, but
I'm not-
there's reference to owner.
Yes,
Owner.
yeah, my exactly. So, and he had already arrested, my lord. That person, the manager already arrested.
No, manager has been arrested.
Yes, yes, Sadhu.
This petitioner is the owner.
Yes, he is the owner of the hotel. Not owner, madam, he has taken on the rent. Owner of the land is the Vajapur.
Owner of the land is different. He is the owner of the hotel.
Lease, but he has taken lease.
He is the owner of the man. Look, the only two things bother me, sir, at this stage, is that the girls are minor. They've been
But I
recovered.
saw a mic role, madam. Naturally, I run through the manager. I have nothing, I cannot see my handicap person. I reside there, my lord. So I have nothing to do, my lord. If I had information,
The victims have said.
yes.
Third, learned senior counsel HRA IU assisted by. Petitioner is seeking anticipatory bail in connection with Porso previous case number 269 of 25. Read with certain sections. The Azhar dated 16/9/2025 was lost by a police official. With allegations that complaints were received from public about running of prostitution activities in hotel SN in that area. And upon raiding the same, two minor girls were recovered / rescued, were found to be entered in the hotel register under fake names. The manager of the hotel, Sadullah Ahmed, name therein is arrested, was arrested. The present petitioner is stated to be the person is the owner of the hotel, which he had taken on lease from one Devojit Boras, with whom the title suit is pending. Also, with regard to the civil dispute. Third, DP Goswami additional DP opposes who prays for rejection of the bill petition, considering its social implication. The present petitioner is stated to be a locomotor disabled person. 60% locomotor disabled person. Seen the annex certificate, and that he submitted that he stays at Mulberry. At this stage, the materials against the present petitioner is that the victims reportedly told the police that they were brought to the hotel by one Lady Rani in connivance with manager and owner of the hotel and engaged in prostitution activities. Despite the nature of the allegation, the nature of the matter, considering the aforesaid statement supposedly revealed by the victim girls, being the only incriminating material at this stage, I deem it fit to allow the petitioner to record his statement. Also keeping in mind his handicap. Accordingly, it is directed that all conduct is directed that in the interim, in the event of a 20,000 satisfaction of the we shall fully cooperate with the investigation. Then help the police to go to the root of the matters. Secondly, will he be able to appear physically?
60%.
He shall appear before the and make himself available for examination. if the petitioner faces any special difficulty in attending physical, he may also initially appear through the electronic. So the petitioner shall not hamper or tamper with evidence in email.
Within 10 days or 7 days time. maybe.
I'm not giving any.
Yes, as you wish.
First, can be through DC.
Always.
Phone also. And then you can, probably you can take a car and go.
Always.
Fixed on 40. So, what? 1410. 1410.
Yes, Lordship. FIR page 10, Lordship. Initially, it was a complaint case, Lordship. Subsequently brought to the magistrate, Lordship. FIR page 10, Lordship. 11, page 12, Lordship. Initially, a complaint case filed by the informant, Lordship. Subsequently sent to the OC multiple then registered a case, Lordship. 11 for paragraph, Lordship. Page 12. Paragraph 4, Lordship. Fact of the case, Lordship. Last page. Complaint was filed, Lordship, after 25 days of the enterprise incident, Lordship. Initially, matter was compromised, Lordship. Subsequently filed this complaint case, Lordship, before the added SDGM Rongia, Lordship. Lordship, petitioner is 18 years, he is a young girl, Lordship. They are the neighbor. They are the quarrel between-
Look at it from.
For 82.
482.
482. So, page number 11. This has been registered under section 25(1)(a) of the arms section.
Only answer.
Only.
Pranab Rungang is your petition.
Yes. Now, my lord, he has said that this, who has surrendered before the OC, my lord, he has stated that as per my direction, he has received it from one unknown person. And kindly come to page number 14, that unknown person, my lord, he was arrested. He was his own friend, my lord. Kindly come to page 14, my lord, ground of arrest. Page 14.
20 or 30?
Page 14, my lord.
Oh. Right. 26.
The unknown person from whom he has received ground of arrest, my lord. Lordship, go to.
Yeah, got it. Page 14.
14, my lord. During interrogation, the arrested person is found involved in the case. He kept concealing the illegal arm with him. And after 2 days, handed over to Sri Tumal Sonwal to deliver Pranab Rungang of Nelly. And he is saying that it was supposed to deliver to me. But my lord, kindly see the FIR. Since my lord, March 2025, he was having the possession of that, my lord, arm. But he has never tried to deliver it to me. For about 6 months, he has kept it. So
This has come from the statement of 22 also.
page number, my lord. 14. Ganesh Boro, the
Since
unknown
March.
person,
Since March.
my lord. And FIR was not, my lord, he has surrendered on 22/8, for 6 months. In these 6 months, he has never tried to deliver it. And the reason, my lord, for taking my name, I still don't know.
So is there a court for this?
We will give you an opportunity to break.
My
the
lord.
step. So this has come through
Yes, yes.
secondary linkages.
Yes.
42, 482. Learned counsel. Mr. Burma,
HRD.
HM, learned counsel. And DP question 482. Bogino DPS case. In which district?
Lucky.
Pranab Longham. The allegations in the other half. In that one, Timon Sunwan. The other allegation and the other half dated 22/8/2025. Is that one Sonowan came to one SI of police and handed over from his possession 7.66 mm pistol, which he claims to have held without license since March 2025. During examination, the Tuman Sunwal stated that it was given to him by one unknown person at Guwahati as per the direction of the petitioner hearing. He submitted that subsequently that unknown person was arrested as Ganesh Boro, and forwarded on 26/8/2025. Peruse the grounds of arrest there. It is submitted by the learned counsel, Mr. Ahmed, that the person that is not the said Sonwa have held the arm supposedly without license for 6 months before he came before the police. The learned additional PP opposes the grant of bail. Call for the case diary of Bogino DPS. In the numerous circumstances, I deem it fair to allow the petitioner to record his version of events. Accordingly, in the interim, 20,000 with consent. Corporate investigation. Appear before IO, making himself available for examination. After vacation.
17th.
17th. 17th.
All that.
This matter may be discussed before approval goes.
Okay. Just.
Are there papers to signify to you with this?
Okay. No problem.
MTech.
MTech. And it got. Number is months. 32. The MTech learned counsel for the prosecution submits them. Earlier bail petition was rejected by coordinate bench on 4/2000. Accordingly, the instant bail petition will be listed before appropriate bench, bracket without B.
Highly.
That's the part. But it is instead
Regular relation, my lord. Today is 81 days in custody, my lord. FIR at best 9.
absolutely. Dacoit, you know, allegation of dacoit.
But my lord, as per my lord, line number 7, my lord, briefing there from BLT culprits. My lord, in the FIR itself,
BLT. BLT culprits, but we are not BLT culprits, my lord, and my lord, we are, both the petitioner are own brothers. My lord. One is my petition number, one is cultivator and two is the teacher, my lord. Teacher of madrasa, my lord. And
Allegations of dacoity are there. From his point of view also.
yes,
If
my
it's
lord.
false, then it's very, very.
And
Both are brothers.
brothers, my lord.
Abdul Rahman.
Yes, my lord.
Kindly, sir.
Yes, okay, so regarding the ELT, my lord, briefing the also I'd like to point out, my lord, at the time of committing dacoity, my lord, look from the FIR itself, they threatened us by using sword, etc. Nearby 1 hour, they have taken for whole home looting time, briefing that they are from BLT culprits. So at the time of committing dacoity, they, my lord, stated that we are from BLT. But it is not that they are BLT members.
Yeah.
It is. Now regarding my lord, the present, there are two petitioners, my lord, here, one Majid Mandal and one Abdul Rahim.
Brothers, one is stated as a cultivator, another teacher.
Oh, yes, on that part, from the, my lord, tower dump analysis, my lord, that at that point of time, compare mobile numbers that we said during initial investigation, from the tower time analysis report indicating the phone numbers of the accused persons with subscriber details. The present accused person, one Abdul Rahim Mandal, my lord, he was arrested. On further analyzing their CPRs, it was found that Sairam Begum was in constant contact with Abdul Hamid, Abdul Rahim Mandal, and Kachu Mandal. So initially, on the basis of the my lord, our analysis,
Location. Tower location.
yes, tower location.
Tower location can pinpoint the exact location.
Yeah,
right?
yes.
In the house, they were in the house
Yes, yes.
at that time.
That is, in this regard, I want to.
Just a minute, let him complete. Come back to me.
Regarding one Abdul Majid Mandal, he is the brother of Abdul Rahim Mandal. Their house was also searched by the police. The looted items were not yet recovered, but some other items they had only single witness. পুলিশে মজিদ মণ্ডল আৰু আব্দুল ৰহিম মণ্ডল নামৰ ব্যক্তিজনৰ ঘৰত তালাচী কৰি উক্ত ব্যক্তি দুজনক আটক কৰে আৰু সিহঁতৰ ঘৰৰ পৰা পুখুৰী, হীৰাদাও, ৰড, 3খন মোবাইল হেণ্ডছেট আৰু চিম কাৰ্ড পাই STPO মহোদয়ে উক্ত বস্তুসমূহ সন্মুখত show in presence of security, but regarding looted items not yet recovered from the residence of the community.
Serial mobile matching is
Mobile matching
disturbing.
the basis of the mobile matching that those accused persons were on that day of the committing of the at the time of committing dacoity, their mobile numbers were their presence at the
In the house.
yes, presence of the location. That is that
At the place of offense.
Yes, Mr. Lordship may kindly to this is a tower time analysis.
Either are today's 81 days, my lord, and one more thing, my lord, the petitioner have two resident, my lord. One is at Bilashpura town, nearby the place of occurrence, and another is
He has denied. Good night.
Yes, both the accused persons.
Which is the, so this one. Sometimes this technical and electronic evidence is very pinpointed.
Yes. of the tower.
Mojid Mondal was not found.
Obviously, regarding Mojid Mondal, he is the brother of Abdul Rahim Mondal, the both are brothers.
Its tower is not there. Yeah, tell me. Let's submit. My lord, today is 81 days, my lord. Either way, my lord, the length of period may be considered. And one more thing, my lord, the petitioner have two residents, my lord. One at Boiseralga and one is at Glashivara town, my lord. Within a half-kilometer radius of the place of occurrence, my lord. That's why I asked this question. That pinpointed location can be found. Pinpoint. I think so. I think so. Otherwise it will be highly risky to rely upon.
Otherwise, it happens that from the tower type analysis from this particular area, some of the suspected mobile numbers.
Yes, suppose that this location and the old building location is shown as same,
Same.
then it will be highly misleading. The person might
Then
be
thereafter,
innocently there.
the numbers which were there at that point of time, those all numbers were collected. Thereafter, on the basis of some of the numbers which were suspected, thereafter police were trying to find out the history of those accused persons.
But according to this,
But yes, there are some other effects also required, my lord, only sometimes only on the basis of tower dam.
no, that is true. But this, according to them, they were decorative. This it was found at the same time.
Yes, same.
Of these persons.
Yes. all
And
these persons.
in the night it was switched off
Switch off.
before going.
So there are.
But not this person. Everything has to be looked at
Mojid-
fairly.
Mojid Mondal was.
It's not there.
He is not. But regarding Abdul Rahim Mondal.
Yeah, it is there.
But he has also found, my lord, his contact with other accused thereafter that mobile number found switch off.
Abdul Rahim Mondal is the teacher. That's a most surprising part. That's well. The shocking part actually. It's really good. We decided. The allegation is there. Dated FIR dated 25/6/2025 pertains to the equality in the house of the informant, looting of valuables in the at around 3 p.m. 3 a.m. The petitioner number 1 is stated to be a cultivator and the petitioner number 2 is stated to be a teacher of madrasa. The case diary produced before the court. The learned P. Bothakur learned additional PP submits that the mobile tower location indicates some persons, including petitioner number 2. However, the learned additional PP submits that the allegedly stolen property has not been recovered, and same including from the house premises of the accused petitioners. I perused the case that as for the mobile location analysis done by the police, 4 persons named therein were found to be present at the scene of crime on 25/6/2025, and the mobile phones were also switched off at 8:30 a.m. on 25/6/2025. This also stated that recovery of some materials like complete etc. from the house of the those named persons matched with the description given by the victims. That raises further suspicion. However, the name of the petitioner, petitioner number one, namely Mojid Mondal, is not in the list with regard to mobile tower location. And also regarding the recovery of materials, suspected materials. Therefore, the accused persons, petitioners are in custody since for around 51 days now. Therefore, the accused Mojid Mondal is hereby allowed to go on bail of ₹30,000 with 1 surety of the likeness, subject to the conditions that he shall render cooperation to remaining investigation. They will follow not intimidate or influence witnesses. Semicolon, shall not hamper or tamper with evidence. In case of violation of bail conditions, bail is liable to be cancelled. However, with regard to the other accused petitioner, namely Abdul Rahim Mondal, considering the incriminating matters and fact that investigation is still in progress, including receipt of, including fingerprint analysis. Despite the length of detention, his bail prayer is rejected at this case. Returned back the case that the bail petition stands partly allowed and disposed of for symptoms.
2 days, 81 days.
Yeah, no. Sometimes it
Only 9 days is left.
No, sometimes it is, it may be necessary to even detain them till the further stage, right? So let them complete the investigation. If it is not, you will automatically get bail from the trial court.
And whether they were
this person let
initially
him go.
4 days in police custody also, madam.
But this person let him go.
Obviously.
34.
In this case, during pendency of the bail application, charge sheet has been filed, so accordingly, the share was called for. I have checked the sheet has been received. So there is a two FIR lawsuit from the petitioner's side and the informant side also. Case 9 is the FIR in which I am seeking bail also. Merit also.
It has been
Receipt, PCR receipt also.
CD, charge sheet has been there. Charge sheet is there.
Yes. Subject on 38/25.
He's in custody since
Lordship says,
10/7.
yes,
10/7.
10/7/2029.
This registered on the charge sheet submitted into what sections? Is it
Basically, on the second 326.
326/307.
Yes, previous number of charges and not. Okay. I fragmentation. 326 and
31. That's your flag. Previous. Simple.
one person is previous information. First, I'd like to point it out, in the FIR itself, there is a basic allegation against the FIR name accused number 1, who actually inflicted the assault, post grievous in the recordship. In the FIR itself, there is a specific allegation.
The injury of Amir Ali Mandal, previous by Sarkovitz.
Charpers.
And I'm not there.
Akilul Damak, sharp and simple.
Investigation is complete. I wanted to have a look at the charge sheet.
Yes.
There's a charge sheet.
Right? That's not the second part of it.
CS.
Yes.
It's not in that format. Still. Nice format they prepare.
That thing.
It is there. First part is there. First part is there.
And allegation against the Resolve Mandal and his son, Sheikh Sabi Ahmed, who had assaulted him by a sharp weapon. Down. This petition has been a statement of the witnesses for specific allegations
Let
against.
him go. Let him go. You are some. Pursuant to submission of charge sheet, scan TCR was called and received. The learned additional witness, P.P. Kosambi submits that as for a medical report, there is previous injuries on one person and simple on another, caused by sharp weapons. He also submits that as per the statements, there is not much materials against the present accused. So he's stated he's in custody since 10/7/2025 after his arrest. The given facts and circumstances. The accused so and so is hereby allowed to go bail over this 25,000 shall be available for trial, hamper or temporary seats. Okay.
Yes.
Anything else? That's all.
To the satisfaction of
Satisfaction
CGM.
of the concerned learned, in bracket CGM,
South Summer Market.
learned CGM, South Summer. Fine. Yes.
In this case, my lord, the scan could was small form, and at the same time, medical report is also
Medical and PM also perhaps.
and the petitioner is in custody for last 108 days. Ma'am.
Charge sheet. It's a error.
2012.
My lord, my lord, the peculiar circumstances, my lord, find the FIR as well as other things, my lord. Actually, my lord, their houses have been burned down, my lord, and they have shifted from Lokhimpur to Nagaon and some other places, my lord, and they are not in a position to go to that places. And this is how they remain absent. And subsequently, my lord, that's of course, my lord, is a on the old case, my lord. But that's the scenario. And because of that scenario, because my lord, one person has gone missing. And the accused number one was together, my lord. Last seen together. And thereafter his dead body was found in somewhere else. And I'm not to be accused number one. Accused number my lord, 3, he is the brother-in-law. And he was not even, nothing has been mentioned in the FIR as against him. And anyway, my lord, because of these disturbances, they have to leave from that district and remain in other district.
And he
then
was sent off for trial in the charge sheet.
my lord.
He was sent. And we.
NBW district.
Oh, NBW resolution.
And my lord, page 16 is the order, my lord. Page 16,
Of your petition.
my lord, of my petition.
Where the restaurant body for trial for on the strength of NBW.
So on this, my lord, on this date, my lord, on the basis of the NBW, my lord, who was arrested.
6/6/25.
Page 16, my lord, and since then. he is in
Got it. The accused is seeking bail in connection with hard to the image for the P.P. Goswami. In connection with North Lakhimpur PS case number 299 of 2012, which after investigation was charged sheet and presently in the court of the learned, presently before the learned court below at the stage of appearance. Next up, GR case number 581 of 2012. They submitted that petitioner was not, there was no allegations against the petitioner in the FIR, but he was arrested on 6/6/2025 and has been in pre-trial detention for 108 days. Next up. He was arrested pursuant to NPW and by order dated 6/6/2025 was remanded to custody by the learned court below. Scan TCR has been received. Actually, the order sheets, we need mostly this. Sometimes we can specify, it will save some time, our time also, their time also. Sometimes order sheets are not this. Is there? Yes. See, yes. So yes, yes.
If there is any inclusive, say Amnet also. Yes, it's for business statement, yes. Some cases like capital. That's what the doctor.
I'm not for you.
Have flag matter, pink color flag, I have flag matter, yes, something.
This I'll find it difficult to read it.
Yes,
Have you read it?
yes,
Tell me the gist. And this handwriting is the problem.
very poor.
Huh?
Handwriting is very poor.
Yeah, 4 minutes. But this regarding this.
The petitioner, the aspirant is not been saying
No investigation. What is the accused? Co-accused statement.
and
Accused number 1, madam.
Prime accused.
I mean. In his form, yes. Giving some factors in Horlicks. Because and price such more, yes, minimum is the head. Head on gets that it in a railway platform.
The London Additional PPS pointed out the statement of the main accused, Sena, and submitted that from there is no implications. Not much, or not much. No,
Not much.
not much implications against the present petition. Nevertheless, as the investigation is completed, charge sheet submitted, case poised for omitted and possibly trial. Therefore, petitioner should be, the present accused petitioner should be allowed to go on bail at least my considered 30,810 available for trial, not hampered or temporary limits. Five petitions, that's around this question.
No, please.
This year, it's going to be a
Confirm.
option.
Also, is there.
Yes,
Please, my lord. I'm trying to get the instruction from our office. Persons to the earlier order of this court. Notice served to the respondent number 2.
yes, yes. Oh,
Yeah.
take instruction. If there has been some amicus curiae,
Yes.
if he or she can go through quickly, then we can take it up today only, because of time constraint. Two.
May I please have a check? No, application under section 483. I was arrested on number 25/07/25.
In this case, earlier, PM report was called for the Curiae available, the PM report. My lord. What do you see?
Where is the file?
FAI which you will find
70. Found it. I'll read. Both are home guards.
Yes, what are Ma'am, on my lord, notice under section 47, ma'am.
What we do?
Which you will find at page 22, ma'am. As per my lord, 47, my lord. Full particulars of the offense for which he is arrested or other grounds for such arrest should be, my lord, should be communicated to him, ma'am. But if we go through, my lord, the Annex 3 at page 22, what you will find that there is no such, my lord, full particulars of the offense, ma'am. That he has been arrested for the offense of, my lord, 103. It is not there, ma'am.
Quarreling with the accused,
Yes, ma'am.
involved in the incident. A little bit is there,
Yeah.
but it should be more detailed.
Yes.
And
Full particulars is not there, ma'am.
should be little more detailed. In any case, investigation is progress, must have progress.
Yes. Is called me to, my lord, his place, my lord. Then, because both were home guards, my lord, they had given money, my lord, for extension of their.
Right. So that's, now over there was dispute. Dispute and the. How many days?
60 days, ma'am. Considering the, my lord, period of detention and, my lord, is 47, 48. I am praying before your lordship to kindly release them on bail.
It is not given.
48 also, my lord, same thing.
Same.
Same.
Let
That is, my lord, lordship will find at 25, 26.
some of the formats,
Same thing, my lord.
they are detailed also and it's bilingual also.
Yes.
Some of the recent formats. So this is actually not so sufficient, right? It is there. Inadequate.
Man.
What are?
Compliance with section 47, 48. Maybe, my lord, incident occurred on, thereafter, immediately thereafter, the assault by the victim succumbed to the injuries, and thereafter, my lord, this 103 ended. Regarding that aspect, my lord, now they took care of it. Complied with. Anyway, next.
Progress of investigation.
Yeah, but
But other than its progress.
really,
Yes, update. What PM should assisted by you should and it comes with important good for this. The accused is seeking bail, the accused namely Noyan Das is seeking bail in connection with Polasbari PS case number 185 of the under section 20. It appears that both the victim and the accused were working as home guards, and earlier the victim was discharged and they had given some money as alleged in the FIR to the accused for his extension. But it did not happen, and with regard to seeking return of the same, the accused allegedly assaulted him, subsequently leading to his death. Learned counsel, Mr. Chaudhary has submitted that drawn my attention to copy of the notice under section 47 BNSS and contended that the same does not comply with the constitutional standards stipulated by the Honorable Supreme Court. The other additional people submits that the said notice is sufficient. In the progress of investigation. Investigation is not yet completed, but there is reasonable progress. However, PM report has not yet been collected. Regarding the notices under 47 BNSS, it is not a case of non-existence of notice. However, in perusing them, I find that considering the principles laid down by the Honorable Apex Court in the case of Rehan Kumar and Prabir Purkasta, to meet the standards under Article 22(1) of the Constitution of India -30. The narration of the grounds of arrest, though partly they are not sufficient vis-a-vis the said standards. Considering the above aspect of the matter, the progress of investigation, reasonable progress of investigation, and the length of detention, I am of the considered view that perhaps the accused can be granted bail at this stage, subject to conditions. So allowed to go on bail of rupees 30,000 once security, subject to the conditions that he shall cooperate with the remaining investigation. So not hamper or tamper with evidence. Be available for trial upon commences. Shall not intimidate or harass or cause any harm to the informant and the victim. Informant and the victim side. Violation of the bail conditions might entail cancellation of the bail. Return back case the petition stands allowed and disposed.
Only when the CGM Kamrup Amin now.
Yeah. Concerned learned court within bracket learned
CGM Kamrup at Amin now.
CM Kamrup.
I am obliged.
Yeah, yes. This is the case of 103 lawsuit. And petitioner is behind the bar for 78 days. Lordship, in fact, lordship, this is a case lordship, unfortunate case. Both the victim and the petitioner lordship, they were from West Bengal. And they are the laborers person. Okay, after finishing their work lordship, they consume alcohol lordship, they were in drunken condition. After that, lordship, some incident was happened and subsequently the victim died. But 78 days behind the bars. Considering the length of detention, in fact, there was no intentional worship to cause death. There was some altercation, and subsequently, worship in abnormal condition, both the victim and petitioners were there. This is the actual fact. Diary receipt. Is a receipt postmortem report. Head injury. Postmortem injury, yes. Is due to hemorrhage following head injury. The size depth of proximity. Eyewitnesses also 3 eyewitnesses. They implicate. Progress of investigations there. Substantially progress. Only things that granted bail, what conditions they are from West Bengal. West Bengal. Both the victim and the petitioners. Oh, also, they were working. Yeah, they were working in mobile homes. Will you be able to give local security? One local. And I don't impose 2 security usually. But otherwise, preferably local security. M. Khan. The allegation, the FIR dated 7/7/2025. For the accused causing assault on the victim, causing injuries and subsequently he succumbed to the same. It stated that both the accused and the informant are from West Bengal working as laborers. And so it appears that prior to the incident, the accused and the informant, appears and that prior to the incident, they might have consumed liquor. Can I record this? Yes, yes. Case diary has been received. PM report indicates head injuries. They submitted that eyewitnesses also implicated the accused. Investigation, I've seen the progress of investigation, which appears to be substantial, but not yet completed. The case stated to be under trial detention, pre-trial detention since for about 78 days, for about 78 days. In the given circumstances, the accused is allowed to bond bail of 25,000 once surety of the like amount satisfaction. He shall not abscond. Number 2, available for trial. Number 3, hamper or temporary vigilance. Not hamper or temporary vigilance. Violation, return back to conditions of the surety should be preferably a local surety from the state of Assam. Return CBP, bail stands exposed. Step 4.
CB has been called for repeatedly for 4 times.
Oh,
We have communicated Lordship, personally I have called him, Lordship, I is on PTC section. That's why he can put in the case, actually, they have paid for what they did.
then let it come on 26, madam.
Or impact with the court vacation. Last chance.
But all to second. The matter is pending for case that just been pending for case that and several dates have elapsed already. They submitted that communication has been received from the IO that he was busy with BTC elections and therefore could not send a case diary today also and seeks another date. Really, because elections are going on just today, tomorrow. Oh, yes, I know someone who's got 23, 24. We'll take a chance. What is the allegation?
Allegation against the petitioner has attacked with a rod in the heads of the victim. That is on the allegation.
Death or injury?
Not
Death.
109.
At least not 26. 26.
Deeply operational.
Issue fresh reminder for the case diary.
Page 10, Lordship, an earlier FIR was filed. At page 23, now that FIR has taken, charge sheet is filed, court has taken cognizance of the matter. Now at page 24, by the same informant, on same, virtually on the same issue, an FIR has been filed. If Lordship sees the page 10 FIR, the both FIRs are contradictory. With due respect, I state that,
Just a minute. Page 10.
there is the first FIR.
Just a minute.
With due respect, I state that I accuse a married man and a father of 3 children. The accused started a rough love relationship with me by falsely stating that he is unmarried. He had sexual intercourse with me multiple times on 26/7/2000 at about 10 a.m.
Wait, please, yes, allow. Lordship, I have a have a look at page 16, madam. 1/6, my lord. Grounds of arrest, my lord. Serial number 2, my lord. On interrogation of the accused number 1, admitted his involvement in disclosed that he had disposed of the stolen ornaments by selling the same to the accused number 2, 3, and 4 in exchange of money. So before your lordship, that 2, 3, and 4 are before your lordship. And now your lordship may kindly turn to page 19, my lord, the seizure list. Yeah, the description of the article seized, my lord. 1 pair of child bangles, 3 pairs of silver bangles, 1 pair of pile, so and so, 2 fingers, ring of silver, 1 tar ring of silver, and 1 store-shaped locket of silver. And the petitioner before they are behind the bars for 23 days, my lord. And the case is registered, my lord, under section 305, man, of the BNS, man. Theft. Stolen property. Yes, but it ought to have been registered under section 3172, madam. It ought to have been,
Which is equivalent to 411 earlier.
yes. And the punishment there is, my lord, imprisonment of either description for a term which may extend to 3 years. They have learned a lesson, my lord, by purchasing, considering the length of detention, my lord.
They are all siblings, but they purchase.
They are brothers, sisters. Brothers.
They purchase the stolen articles and recovered from their own. Main person here who has committed the offense, Lazibun. One person is for Simanto Polita. They have admitted their person. They sold the articles to these people.
23 days, madam. They have
Forwarding report says that all are habitually involved in these things. In that case, it is a little serious matter. It may be wise to allow the investigation to proceed a little further. But however, if that is not there, not only one-off incident, then unless people fall into the difficulties of law, sometimes they don't realize.
Yes,
as you would say.
23 days.
Let me see. I will go through.
Not sure.
I will. Just read this case diary as was dictate the factual parts. Or if you will hurt, NJ doctor assisted. Your good name, please. Yes, Pradhan. Yes, Pradhan. Happy Goswami additional. Petitioner who's stated to have been arrested on 31 seeking bail in connection with this case number 157 of 2020. Section 305 JNS. This arose out of Izahat dated 24/8/25. With the allegations that on the same date, due to taking advantage of non-availability of members of the family in the house, unknown miscreants broke into the house and stole belongings and valuables, including the gas cylinder. The accused were stated to have been arrested during investigation. And as per the forwarding report, stolen property was purchased by these accused persons and were recovered from them. Will it be early enough to prompt in this case? Habitual thieving is there.
Well, habitual, my lord, reasons for arrest, my lord.
Number one, it says, stolen property or ornament gas cylinder were recovered from the possession of accused number 1, 2, 3, and 4. Number two, my lord, all the accused admitted they have habitually committing theft. But theft is in regard to one matter. 2, 3, and 4.
So I have flagged down all the statements of.
Then take a seat. Mine. Main accused is Rajibul Islam.
Rajibul, yes, fine. Another two persons are there. Simanto Polita.
His statement, he said that he schemes to take drugs. This problem is there. Yep. Right. 2 minutes. Bail objections. I did not find it.
Let's talk about there's something that's specific.
Sometimes they contain certain
Yes,
things,
yes.
summarize certain things. What additional people? The case diary has been placed before the court, along with along with relevant portions flagged. Peruse the relevant portions of the case diary. There appears to be significant materials against the main accused for prima facie about involvement in the house trespass and theft and theft in question. Main materials against the present accused persons are that they purchased stolen property which were recovered from their house. Statements of all the 3 persons are on similar lines, in which they have stated that they purchased some articles at cheap price without ascertaining as to whether the items were stolen or not. There is some progress in investigation, but the same is continuing. In the circumstances, perhaps these 3 accused persons can be allowed on bail at this stage. Though they were arrested on, help me with the date, 31/08/2025, subject to suitable condition. According to bond 25,000 each, surety of the life insurance. The satisfaction. Number 1, shall not abscond, shall cooperate with remaining investigation, shall not commit any offences or indulge in any illegal activities. Shall not hamper or tamper with benefits. On case that your petition stands allowed and CGM come to matter. I'm sorry, Learned Court, Season, Kamrup Metro, Aming Metro. I'm applying.
May please, Lordship 483, Lordship. I am behind the bar, Lordship, 86 days, Lordship. It was arrested on 29/6.
What section?
Lordship 103 is there. Lordship, who was already allowed to go on bail after perusal of the Curiae. Where page, Lordship 8.
Minor daughter.
Lordship.
Earlier petition, your lordship was pleased to observe at page 19, paragraph 6, that the role played by this petitioner, as per the CD lordship, at paragraph 6, line number 3, that the said Ghulam Nabi Azhar subsequently assisted the accused in beating the deceased, the body of the deceased. This is his role purportedly as reflected in the
Husband of
CD
the,
lordship. Yes.
husband of the, this other accused.
Yes, lordship.
Rahima Khan.
Yes, Rahima Khatun's husband was killed.
Yes.
And
I
the
remember.
CD says, and in the 164 also, she admitted that under some circumstances, the incident
Happened.
occurred. And now this petitioner is before your lordship that the allegation against the present petitioner is based under 238 of the BNS law, which is available lordship.
Yes. This, they were arrested together.
No,
It's maybe.
this is AB lordship. This petitioner was not arrested.
And he also wife of the deceased.
Wife of the deceased,
He was arrested.
who is purportedly the main perpetrator of the offense law. She has been released, and this is under 482 lordship by the accused, co-accused, whose name only came in the forwarding report lordship. In the forwarding report, that is at page 17 lordship.
Investigation is not complete, right?
Yes,
Investigation is not complete.
but only because of the statement of the this wife, main accused in this case. His statement is there, he said, yes, but it
Very, and that is the, what is immersed.
yes,
But his full role may have to be investigated, right?
yes.
So, and what is the outcome of any investigation into his complete role, if any? Because, will it be prudent to grant anticipatory bail?
That part is also there. Otherwise, this is concerned with ৰবিবাৰে মাকৰ ওচৰত হাত পিচাই গম পাই যে মাকজন ঢুকাইছে, তাই তাক ভাইটি গোলাম নবী আজাদ ঘৰৰ হাত চিনি তাক ফোন কৰি মাতে আৰু এজ পাৰ ষ্টেটমেণ্ট উইটনেছেছ আৰু ষ্টেটমেণ্ট ইয়াৰ মোৰ স্বামী ছবিয়াল ৰহমানে যোৱা ইমান তাৰিখে মদ খাই মোৰ কাজিয়া লাগে আৰু মোক মাৰিবলৈ আহোঁতে মই গটা মাৰি খাটিয়াত থাকি তেওঁ মোৰ মৃত্যু হ'ল। মই গোলাম নবী আজাদক মোৰ বন্ধুক মাতি পিছদিনাখন ৰাতিপুৱা ঘৰত গাঁত খানি দিলোঁ, মাটিত মাৰি চিকাৰ হ'ল।
This custodial, will it hamper investigation? Whether his custodial examination will be necessary to fully ascertain the circumstances of death. Right, that aspect is coming to my mind. Otherwise, it can be allowed.
My submission is that the daughter of the deceased was also examined and was present there 14 years of age lordship. In her statement number 164 also, this same thing has emerged, that the incident took place due to her mother, and subsequently on the next date, this accused person was called to assist in bail. This much is there as per
আগতো পাপা যায় ঘৰত কাম কৰিবলৈ বেলেগত মায়ে গৈছে।
Yeah, I remember that.
That part is in that.
I should provide lordship condition any.
Record your statement.
Lordship.
Whatever has happened. Page 18, my daughters. Next to one, two, three to 8. The allegation against the present petitioner is that after the death of the deceased. His wife called him and he assisted her in burying the body. The learned additional PP, on the basis of the case diary, submits that similar factual matrix is revealed from the statement of the daughter of the deceased and co-accused recorded before learned JMFs. The main accused / co-accused Rahima Khatun was enlarged on bail by this court on 16/9/2025. It is submitted by prosecution that there is progress in the investigation. Complicity in murder, so far it has not emerged. Can I record? Or you are not comfortable?
With the case diary of the next part is here. So he has assisted in later.
So far, the materials against him appear to be that his assistance in burying the body. In the circumstances allowing this petition for pre-arrest bail is directed that event of arrest 25,000 with one silver, subject to the satisfaction of the concerned learned court within bracket learned court. This will be Jalupari would be Metro. Metro.
This is PS Lordship. The police station to be done.
To the satisfaction of the arresting authority. Arresting authority.
Is the arresting authority.
The following conditions are imposed. Number one, the accused, no.
Yes.
Arresting authority. Number one, he shall not abscond. Number two, he shall appear before the IO for examination and render full cooperation to the investigation. Number three, he shall not intimidate or harass the informant / family. He shall not hamper or tamper with the violation. Return back the case that AB stands allowed and disposed of.
Obliged, Lordship.
What is it? Instruction, yes.
I am simply.
Oh, regarding notice.
Yes, service completed, madam.
Service complete. This one, Amicus. The scan TCR has been received. Further, based on communication received in this regard, the learned additional PP submits that notice has been issued. The notice sent upon the respondent number 2/informant has been duly served. So we appoint the Amicus. M.K. Brown, Learned Counsel, is hereby appointed as Amicus Curiae to appear on behalf of the respondent number 2/informant. The learned Amicus shall be furnished with a copy of the petition. So registry will furnish, we can take it up.
Yes.
Day after tomorrow. Or tomorrow.
Day after tomorrow.
Yeah. Tomorrow also. Will it be furnished so fast? Yeah, I think one day we should. Day after tomorrow. Right. List on 24/9/2002. You want this back? Keep it.
If like we could see the case that I have made a prayer before you. So it's not a big, with the case that.
May I please your lordship? Lordship, here in this case, lordship, the petitioner is in custody since the 61 days, lordship. My submission is that lordship, his statutory period is 60 days, lordship. Oh. Is it? On the last occasion, I made that submission. It's 1091 is their lordship. And that is attempt to murder. And 109 has two-part murder.
Yes, submitted.
Yes.
Just a minute. Some parts may be 90 days, some parts may
Yes,
be 60.
yes. If we assume that lordship, for the sake of argument, the entire FIR is true, then also lordship, there is no allegation.
Must have been.
We have received a communication on 29/25. So today is 22.
What is the communication?
I was busy on LODP, but if it's not available.
Another good. But let us check this. You must be right. 109 must be. I forgot to know. We'll see the FIR again.
Yes, ma'am.
No, prosecution guide. I'll see this, checking this. Imprisonment up to 10 years, non-bailable. If hurt is caused, then up to life.
Yes, ma'am.
Or up to 10 years. The first link would be 60 days.
Yes.
He was first remanded on 24th.
24th, 7.
On the same day, arrest.
Case
Because
number 15.
as you know, it's counted from 10 days. Not from the day of arrest, from the day of remand, which may be same as day of arrest.
Yes.
Or maybe different. Yeah, after next day, that means.
Page number 15 is there. 15, one page. This is the FIR lordship lost after 1 month and 12 days.
Where is the forwarding?
Is at phase number 28, my lord. At the top, date is there 24/7. Page number 28, annex 3. 28, my lord.
Oh, this one is 24/7.
24/7. Yes, ma'am. Page number 15 is there.
Investigation is not complete, obviously. Not complete. And just see the agenda.
Yes, ma'am.
That Manipur case. Any submission, any other submission? If statutory period is complete, we have to grant. That he said this was tied to the court, but it has to be hurt caused while attempting to murder.
Yes.
So, next one for the court, like, we got to know, keeping this. 7 arrested on 24/7/25. And As for the forwarding report, it was also forwarded on 24/7/2023. It is submitted by learned counsel that calculation is fine, no? 24/7.
madam.
I
Calculation-
use that date calculator on this. It's a software date calculator, not software, it's a website. There are many like that. So that we should not be, you must have calculated.
Yes, my lord, I have calculated.
It is submitted that the accused has completed 61 days as on today and has become entitled to default pay as regards. The alleged facts fall within the first link of section 1091. In wherein the offense is punishable up to 10 years. In case death is not, in case hurt is not caused during the offense of attempt to murder. I have perused the FIR and I find that contention to be correct. The learned additional TP submits that the intimation has been received from the IO seeking another date as he is busy on law and order duties. It is clear that investigation is not yet complete. And the applicable statutory period will be 60 days. Therefore, allowing this bail petition, accused is allowed to go on bail of rupees 25. Once severed. The section of the concerned learned court, subject to the condition. Concerned learned court is not going to be.
Its lordship.
Will it be JMFC Boko?
Yes, my lord. Judicial Magistrate First Class Boko.
Concerned learned court within bracket, learned JMFC Boko. Will it subject to the conditions that he shall cooperate with remaining investigation. Semicolon, remain available. Then semicolon, not hamper or temper. Bail petition stands allowed and dismissed. Therefore,
I know. 46, my lord, it is anticipatory bail, lordship.
I'll just come up, some problem in the house. Just a minute, my child fell down. Yes.
My lord, 46 is lordship out of the same FIR, lordship. This is anticipatory bail, lordship. She's a lady, lordship, and her name is there on because of the reason that husband was arrested, lordship. Item number 45.
Connection.
Connection.
We got statutory bail.
Yes, ma'am. This is AB, ma'am.
This
is AB. May I pray that lordship may alter the case diary, lordship, and in the meantime, lordship may kindly allow me to record my statement, lordship. I'm a female, lordship. I was even not there, lordship, on the day of the incident.
She is
She's the wife of
Johiran Begum.
Yes, ma'am.
Johiran, wife of Hamza.
Yes,
just a
Is running.
there.
Name is there, please. And this FIR was lost on 22/2/2025. And in the FIR, they have stated that the LS incident was occurred on 10/1, 1 month and 12 days. Mine. I will record my statement, lordship. Lordship, can you?
Just a minute.
Mine.
The case arose out of the fire dated 21/3/2025. The gist of the allegations that negative. The gist of the allegations in the FIR, wherein 5 accused persons have been named, is that the informant victim was kidnapped by them in a vehicle and eventually taken to Manipur, kept at a place from where she managed to escape and contact a local village headman.
He might petition informant to be made.
Informant and contact a village headman who helped him, the victim, helped him to escape through Imphal airport, to Imphal, and finally reached Guwahati. Yes, prosecution. The case diary has been received, not in connect. Oh,
I cannot put.
with the one named co-accused, FIR named co-accused, who happens to be the husband of the present petitioner, who granted default bail to him by another order.
Because
Yes.
husband is.
Thanks, yes. Considering the learned counsel points out that the FIR was lost after about a month.
1 month and 12 days.
After about a month of the alleged incident. However, from the narration in the FIR, I find that only after she could escape from her alleged detention in Manipur, she could file the FIR. It will be necessary. It is prudent to peruse the FIR, the case diary for adjudicating this bail petition. Should some protection be given to record the statement?
Yes, ma'am.
Which is this protection or not necessary? Because she is alleged to be in the information, one of the alleged accused.
I will cooperate, ma'am. Let me read the statement.
But the role attributed to her along with others is similar.
Just one line is there.
From that point of view, AB is not justified. From another point of view, there may be some.
Yes, ma'am.
23.
Paying for only interim.
Since a couple of months have already elapsed since the registration of his lodging of the FIR. And investigation must have progressed to some extent, at least in this time. Till perusal of the case diary, the petitioner who has given an undertaking in this regard can be allowed to appear before the IO and record her statement. And also put forth her version of events. Accordingly, we issue fresh requisition for the case that we are in the interim 25,000 on severity of the lacking. The satisfaction of the arresting of one. Subject to the condition, cooperate in the investigation, appear before IO. To make herself available for examination, not hamper or temporary. List after 17.
Item number 60 is connected, my lord.
60 is, that is AB or?
That is BA, my lord. And here, lordship, I have not completed the statutory period.
45 days. That is a BA.
BA, lordship, 46 days, lordship, as on date.
But if we synchronize this with this, then I think by that time it will be over.
Yes.
Statutory period will be over.
Yes. Another 14 days.
We should see the case diary, isn't it? Who is this person? FIR name?
FIR name.
Case number 4.
The case diary as called for has not been received. Issue fresh requisition. List on so and so date for bail hearing.
26.
Both of them.
Let the AB be there, lordship.
AB.
I have to record my statement there.
But in the 17, then the state people.
Yes. Yes, ma'am.
Yes, that's what I was saying.
Let's try
So
on
AB, that one AB, let it come on
let it be on 17.
17. 17, 10.
1710.
And this one, 26. 26, 9.
And
AB is not started. Issue bail hearing. And would you mind if I quickly finish the AB bail hearings? And we can take it.
Yes, it will take time.
Bail hearing, 47.
May I? Worship in this case, petitioner in interim notice fee appears. Employer is paid 10%. So 9.
Receipt package earlier you update case we have solved for. That is not received yet. The only thing is that otherwise she have appeared in statement recording.
Case is up to, diary is up to date till
Really up to the court. 9824.
Oh, I remember. 1908.
That's it.
Not very outdated.
Not very updated.
No, it is not fully updated,
Earlier-
but not very old also.
Lots of.
Not very old also. He committed suicide.
Yes. By drowning.
And who's this petition?
If not is working along with him, not to be the same form. And for the witnesses for the statement of the house, they have some relationship.
He is the employee notice and the man who's committed that is the owner of the. The FIR was not by the family members of the shop owner.
Yusuf committed suicide. Blackmail.
Actually, Yusuf and two brothers, they are the owner.
Fortunately. Who is this person?
He noted, she is the employee.
Also, they named FIR.
Named FIR.
And informant lordship is the cousin brother of Yusuf, not the brother. The owner is the Ayan Siddiq and Yusuf lordship. They are-
Pranita Chakraborty. Main accused. Named accused.
It was due to antemortem drowning.
Antemortem.
Interim was also granted lordship after terracing the city.
Right.
When he was in the bank of the river, then called her. But saying that our relationship will not accept by the society because of the defense of religion. That's why he committed suicide and they found him out of the
This deceased.
For a statement of the
Deceased.
by petitioner also. Yes, appearance statement recorded. This is called him when he was in the bank of the river. They don't, he was recovered from the river. Reach roads. He has blackmailed her by allegation.
Like, that is that part of the serious part of the allegation is that part. Death is of course very unfortunate, but abatement remains to be seen, but that part is.
We put a case by that particular refractory in the case, so that's why.
No, I get absolutely. Cooperated. What happened has happened. 482 heard. 482 Jalupari PS 186. 08 BMS. The list of allegation in the. There's a FIR dated 24/4/2025. Is that the deceased was owner the owner of one clothes shop in Guwahati, in which the accused petitioner hearing was an employee over some relationship issue. She started blackmailing him. She started pressurizing him. Pressurizing / blackmailing him. Eventually resulting in suicide of the victim. By jumping into river. Petitioner was granted interim bail on 14/8/2025. Whereupon she stated to have appeared before I and recorded her statement. Dash, which is confirmed by the learned additional PP Goswami. It is submitted by prosecution that former statement, it appears that due to concerns that the deceased had concerns about acceptance of the relationship due to by society due to difference of religion. Blackmailing part is not there. The materials learned prosecution submits that upon perusing the diary, he did not notice materials indicating blackmailing by the petitioner. The circumstances and also especially the C has rendered her cooperation to the investigation. The interim bail granted on so and so. 14/8 is hereby made absolute, subject to the condition will continue cooperating with the investigation. It shall not hamper or tamper with it. Return case that AB stands disposed of. 48.
48 and same, but subject cases.
What is the section?
EPR and voter statement recorded motion. 109 is there also.
1182, 109, video portfolio.
Third. February case number 124. On 10/7/2025. Interim bail was granted to the petitioner. Pursuant to which he stated to have appeared before the and his statement report dash, which is confirmed by the prosecution presented by PP Goswami. It is submitted order that in the meantime, case has been charged sheet. View of completion of investigation and cooperation rendered earlier by the petitioner. The interim bail granted by the authority hereby made absolute, subject to the condition available for trial, informed convictions, and shall not hamper or tamper with evidence. The other one is same day.
Same day interim motion.
No. This is just wait. Same, three rights. 10/7. 10/7. So identical order.
Diploma.
Well, since the man of the petitioner is the lady law officer of the Housing and Urban Development Corporation under administration of the Government of India. The man applying the page number 39. The matter is pending before the tax recovery tribunal. The complainant is actually broad, the company director. They have no FIR against the law officer. The reason behind the closing of this FIR is whenever they close the debt recovery tribunal with any document, the FIR goes by the complainant with the statement that the FIR the document is forged signature.
Just wait. case diary has come. Kindly read the FIR. Let us read
Right,
the.
right.
together. Like to inform them.
Yes, ma'am. I would like to inform you that during the trial, GRT, applicable here, GRT case number, OA number such and such. Hardco versus Megas Constructions Private Limited. One Mr. Subhas Bose, such as the Assistant General Manager, to file an affidavit where a copy of the escrow agreement and other related documents have been attached, which contain the full signature of both myself and my wife. My lord, here, my lord, the Subhas Bose is someone else. My lord. I'm not sure.
We
In
filed
this-
the dispute PS case.
Right. In this connection and forgery, I had already filed a case at Dispute Police Station such and such, which had been already charge sheeted by such and such, where the FSL report proves that the both the signature are closed. Two cases has been earlier lodged.
One CID, one this.
Yes,
dispute
yes. And this is the third number FIR. Moreover, during the trial, at the same OA number such and such, Hardco officials also produced other forged document against which I had filed CID case number 63 of the 14 under section such and such, which was also charge sheeted number such and such, where two FSL report proves that our signature were forged. Now, my lord, as per the as trial of the DRT case is hearing final hearing, so to avoid the punishment, my lord, DRT never give punishment. So to avoid the punishment, Hardco officials, Mr. K.M. Chanda RM, Mr. Subhas Bose AGM, Mrs. Nilali Hazarika XRM, and now my name, Sangeeta Das, law officer. My lord, my duty is one.
Just a minute. With connivance with CA so and so.
Connection is Rajesh Jain, CA, Mr. Anup Kumar Nath and Mrs. Munmul Nath, with director of the Megas Construction Private Limited, having been using one after another forged document to delay and avoid the final hearing for last 9 years. So I hereby request your honor to kindly register case number such and such. My lord, here I'm the law officer only. My job is to only see the legal documents have been executed or not. My department is law department. Loan sanction department is separate. And the the complainant is the one of the director of the Megas Construction Private Limited, and they have taken them.
That means, the informant is alleging that there were on 3 occasions there was attempted forgery.
Yes,
One for a dispute police station, then CID, and this is also same allegations.
Same allegations because
So different documents.
different document, but one loan account.
So anyway, this is what she.
And the
Informant name.
informant
Santanu Dutta.
Santanu Dutta is again the Assam police officers. He is presently working in the Assam police.
Assam police.
Earlier, one of the director of the Megas Constructions Private, who has taken them.
Earlier he was working in the same company.
The director of the company taken the loan from the Hardco matter and loan sanctioned by the Hardco authority.
Okay. Now he is police officer.
Now he is.
Anyway, let us see.
Obviously, it's safe for what is there in the FIR that people will be some sort of regarding submission of those documents. And here in the present case also during while one PRT, one case is going on, that case regarding the sample some those documents or something it is question. I has investigated regarding all these documents regarding earlier cases also. In those cases, search sheet submitted, all those search sheet number itself, FIR itself reflects everything, what is the number of cases in those cases, search sheet submitted. It may kindly page this portion of the.
This FIR was closed in the 2019. Present of.
Present one. 19.
2019, man.
19 only. 2016, 6 years.
FIR is
Investigation is not complete.
in this case, my lord.
Not yet complete. That's not your fault. But long time nowadays it doesn't take.
And since
Now it's much
General
more
motive, that's why-
being enforced.
that's why I'm noticing this.
What should I see? The bail objection? Order.
Yes, my lord, regarding investigation part. Note. Yes. Same, my lord, what is there in the FIR mentioning earlier cases and now presently in the cases of the, it seems that almost for the allegations are same. They need their custodial examination. Just 1 years. No, direct, there is complicity, if there is no direct, materials, then it would not be fair to deny.
The law officer, my lord.
Deny,
I have nothing to do with the sanction.
Take the person or the risk going to custody, but if there, this is a forgery after all, allegation of forgery, if there is implications, and you just see it from that point of view, whether her examination is required, whether her bail is required. Yes. Or not. You'll also kindly fix it day after tomorrow. Day after tomorrow, you need some time to go. Well, let me, no, I can fix it, no. Otherwise, prima facie, it says that earlier those cases submitted and allegations are almost same. And regarding CSD law officer against the law bail objection is also there that same person same dealing with all these cases, she is responsible for filing all these cases. So, my lord.
Regarding the filing of the cases, my lord, being a officer of law officer, I have to file for the recovery of the public money.
Yeah, let me see. Here's a detailed parawise objection. I hope. This case is being investigated by CID. Yes, CID. No, let me see. Can be disposed of. Once they can fix, no problem. No problem. We make some significant contentions. I no doubt cannot be brushed aside just like that. This has to be thought into. Main thing against this investigation is the time frame. It's progress. Shouldn't take so much time also.
They involve me because I have filed that recovery proceeding abetment.
How old is our child? You have any instructions?
She may be 13 for you. This is the widow, the media officer is the widow. Widows, this is the widow. So a single child.
Okay, you want some time to take fix it day after tomorrow. Yeah, that is not.
May I suggest, my lord, can I be allowed to go and give my statement? And in the meantime, we can.
No, I will have to send back the case. Let's fix it tomorrow, my lord. Not this final stump of final education. Even in final education, sometimes that flexibility can be there. Let him study very serious and oh, that is there.
So last 2-3 times they have taken time over the study of this.
No, day after tomorrow will take us. Wednesday, Thursday, Friday, we'll have to seek longer if necessary. Last day to certainly. Anyway, the case diary is received also. Case diary is received. And some arguments are addressed from both sides. I have learned additional PP 6 another date for further studying the case diary.
Bail objection also received. Wherein IO has strongly objected to grant of bail. List on 24 9 CDB rating. Problem. See, on that day, we'll pass the order, fine.
But
As to a lot of matters. Say, oh,
The price is 11. There's no 11 is there. Please go to this. FI was more than 11,324 in March of 2024. March, the FI was
March 2024.
20. The FI, people is the FI said that it's suspected. The last part, the allegation against me. Last part of the FI. There's no 11.
Jorhat matters, I have to just see one thing extra, that whether I have passed any order. I don't remember. I usually remember cases by name of the petitioner. No, my order, your lordship order, I passed the day before, I passed it. Rejected. 13-5 condition. Another bench. It appears that it did not ring me actually. You have not placed this, I would have missed. Didn't ring, the name did not ring. Drug peddlers, Mohsin, Raja, oh. It's a case of that.
Missing and the don is dead, but he was reported to the law.
Jorhat, yes, anyway. The petitioner side has clearly annexed a copy of a bail rejection order filed by self on 13/5/2025 as then session judge Jorhat, rejecting the bail application. Therefore, this bail petition, CD had been received. This bail petition along with the received case that may be placed before another bench, not having other than me.
Wait. That was called. It was received by yesterday. I have made a fair.
What is the allegation?
One and 133.
No. No, it is
316 and 310, 284. What you find the FIR that page?
I'm remembering also. It was sold in Silchar or something? No, but Rupam Sakya.
That vehicle was actually Rupam Sakya who sold to this petitioner.
Rinku Das.
Rinku Das, and that was kept. He has a whole used car shop here. And that vehicle was parked in front of his that used car shop dealer. And from there, that vehicle was seized. And
That is not come.
I have made a communication that you can.
Should I fix it on Friday?
Yes,
Since it's not on entry.
It is from Palmador.
Is there, take a chance. Is there a noted receipt? Issue reminder. List on 26/9. Stop taking. 60 only. 62. 45. Connected with 45. Ferguson. Only one. Discuss scan copy of the.
Let's that has been received.
It's amazing.
Will it be records without, and nobody stated against the present petitioners, my lord.
Diary not received.
Scan copy.
Can copy.
Charge sheet at least.
Yes.
Interim is there.
Interim is there.
One against one.
Yes, ma'am. Petition number 2.
In the best.
The search sheet without. The search sheet. The petitioner's name has not been sent up for trial.
Who? Petitioners.
Yes, ma'am. And this, let me see.
Minara Begum set up.
No, no.
Bahanur Ali also no.
No.
Just see the charge sheet and confirm that they are not sent up for this. They are not sent up for trial.
Yes.
And see, check. Which are kindly do so. So, scan capacity. Or I can also see. You see it. What are you?
In the meantime, but you can take another one time going by the side.
Avoid one. This is like last 925 possible. On 9/9/25, petitioner Minara becomes was granted interim plea is good. Today it is submitted by the learned petitioner council. That's in the charge sheet that he has been instructed that in the charge sheet both the present petitioners have not been sent up for trial. The scan TCR has been received. Learned additional precaution. Confirms this. Just see the column. Bahanur Ali and Minara Begum alias Albun Nisa. Which is confirmed by the learned additional people. In view of the same, actually it's not necessary, but since the interim has been given, I'll make
Yes,
it
that may be.
the interim bail granted to the petitioner.
Petition number 2 was.
Petitioner number 2, Minara Begum, alias Albun Nisa, is hereby made absent. Anything with regard to Bahanur Ali? Not me.
Absolutely given.
No, he's not given any. He's not on interim.
No, my lord.
Actually, for him, it is not maintained. Further, no, it is not necessary actually. In the event of arrest of Bahanur Ali, other petitioner Bahanur Ali, connection with this case, he may be allowed to go on personal bond of 5,000.
Yes.
The bail petition stands allowed and disposed of the procedures. 61. What are the order matters? Order matters are there for suspension of sentence? Yes, ma'am. That will take some time. Suspension of sentence. And this one, IA in revision. Anybody there? IA in revision. And admission matters also. Which could be. Let's take that. Start. CBI counsel. CBI matter.
My lord,
CBI matter.
myself, my lord, my lord, the 126/12/2024, my lord, the learned trial court has passed the judgment whereby convicted the present petitioner for a period of 3 years under section 324 and for a period of 1 year under section 3B. No, since here, Sarah started, we take that. And take up your, take much less. 62, right? Yes, ma'am. Will not take much time. Yes, it. So 307 for 1 year. In total, my lord, 307 and 324, 4 years punishments. Out of this, my lord, 9 months, 6 days already over. Correction. What is the total sentence, sir? My lord, under section 324, 3 years, and under section 307 IPC, my lord, now it is 109. It is 1 year, my lord. 1 year sentence. 1 year, and under section 118, present DNS. Earlier it was 324. It is 3 years. In total, 4 years. Both the punishment will run together. And for 307? 307, my lord, 1 year. 1 year. Yes. So the highest sentence is 3 years. Highest sentence is 3 years, 324. In total, both the sentences will run together. Concurrently. So the petitioner has already undergone 9 months, 6 days, my lord. In total, 270 days. As on 22/9/2022. It was a suspension. 714 process suspension. Study the this thing materials prosecution. I'll just dictate the factual part.
Records. Sentence.
In the IA, the informant has to be heard. Not necessarily.
So rigorous. 324 IPC 2 years.
Highest is 3 years.
Yes. And to suffer rigorous treatment for 4 years under section 3075 IPC. Pay final is 5,000.
Out of 3 years, he has undergone how much? My lord, 270 days, my lord, in total. Approaching, yes, as on today. 9 months. 9 months. And there is none in the family, my lord, except this old lady, my lord.
And I can be disposed of main.
No, I have mentioned now on the actually no that calculation can be actually made. Actually, it's very easy. Yeah, if you use the manually also it can be made. With technology, even easier. What is the average time being taken by the criminal? This is a very useful static. It can be quoted in order also if it is formally calculated, but if it reveals embarrassing statistics that it should not be recorded in order. But anyway, so this that judgment we have seen, which was submitted the other day, Curiae method. I'll dispose it. Heard?
Only I can be disposed of.
Only I. Yes, I can be disposed. The convict appellant is seeking to file a criminal appeal against his conviction and sentence by the learned court below. In sessions case number 50M 2019. Supu Hemron. This you can sit down. Both of you can sit down. However, the criminal appeal has been admitted for hearing. Yes, already. It has been admitted and has joined the queue for hearing of single bench criminal appeal. The interlocutory application has been filed invoking the provisions of DNSS within bracket earlier 389 CRPC, seeking suspension of the sentence and bail. Full stop.
it may be mentioned herein that the applicant convict was convicted and sentenced by judgment and orders dated 26/12/2024, passed by learned additional session judge FTC 1 Margarita Tinsukia in sessions case number 15 of 29, whereby he was convicted under 324/307 IPC and sentenced to undergo RI for 2 years. Within bracket for 324 IPC. And RI for 4 years. Oh, it is 4 years. 4 years. Go to 4 years. Under 307 IPC. The 4 year RI for 4 years and fine of 5,000. For within bracket 307 IPC. In default, RI for 3 months. Third, learned additional DP Goswami, who submits that prima facie there's no impediment, there is no infirmity in the impugned judgment and order. Next paragraph. In the case of it has been held by the Honorable Supreme Court in para so and so that for short-term sentences, the suspension of sentence should be the norm and should be the norm, and it should be refused if there are other significant factors indicating to the contrary. A sentence of, as the sentences have been imposed concurrently, the convict appellant will have to undergo 4 years rigorous imprisonment, 4 years RI, unless remitted earlier. The said sentence would be, in my considered view, a little above a short-term sentence. Considering the fact that as far as jail sentence is concerned, under the present laws dash lies a sentence of non-remittable life imprisonment. It cannot be denied that, considering the pendency of criminal ethics, including several old pending ones waiting in the queue for their turn at hearing, there may not be immediate prospect of disposal of the appeal. The convict appellant is stated to have already undergone sentence of 92 days.
270 days.
Oh, we'll cross check. 272 days. From ever since he was convicted and sentenced. Considering the above aspects of the matter, and to meet the risks or mitigate the risks of the convict appellant undergoing a substantial part of the sentence before the hearing term of his appeal comes. I deem it prudent to grant bail to the convict appellant after suspending his sentence. Accordingly, in exercise of powers under BNSS 389 CRPC, the execution of the order of sentence filed order dated video. So the top is hereby suspended till disposal of the appeal. Full stop. Further, the applicant convict is hereby allowed to go on bail of rupees 30,000. Can you manage?
My lord, 10,000 because labor, my lord.
Huh?
Labor, my
No,
lord.
everything will be.
My lord, his
The fine
mother
will
is,
not be.
my lord, his
suspended.
mother is, only mother is.
Fine will not be suspended. Fine will be suspended.
Fine will be suspended.
I'm suspending everything. Execution of sentence only. The further, the applicant is allowed to go on bail of rupees 30,000 once security of the life to the satisfaction of the concerned learned court within bracket learned additional session.
Yes, madam.
FTC Margaret.
FTC 1 Margaret.
The following conditions are included. He will appear before that.
Yes.
That's simple.
Yes.
Every 2 months. Every 2 months.
Yes, after every 2 months.
But if you face any difficulty, then that flexibility and
Yes.
getting, you can pray to the court. If the court agrees, the 2 months not a problem. In fact, if he is somewhat unable to engage a lawyer also, he can appear personally also, no problem. Bench assistant can always help. Every court will accept him. The interlocutory application stands allowed and disposed of in the aforesaid terms. Criminal appeal, we have to pass an order to them, nothing.
Yes. So they can go.
First order dated 10/9/25. This here has been received. And matter directed to be listed for hearing in usual course. This for hearing in usual course. Okay, so now you can take out this. CBI, okay. Okay. We should clean some of it's getting leftovers. The mention of the orders for this, they also they must be. 60, I think they are waiting for a long time. So what is your matter?
63 items.
What is the matter?
Dosti service was done, your lordship.
Oh, okay, he's undergoing the sentence. That also is. So let me take up the CBI matter. CBI matter, and then I'll hear it at the end.
I think 27 application.
Vacation is 27. Unless it is very urgent, we'll probably, probably our time will be taken by bails only this week. Both IA bail and the normal bail. 27 list after vacation. Any interim order? No.
Lordship, item number 28, my lord. Interim may be
Become free. Criminal division. After vacation.
After vacation, interim may be continued.
List after vacation. You can take
Interim may be continued.
the interim, right, order dated so and so stands extended to the next week.
Most of them.
You see the date for the CIS. Plan a date.
My lord, I have to mention 56 yellows.
You are that day also you were seeing something. 56.
56.
You have been waiting for a long time. 56. Would you mention it after vacation?
After a date may be fixed.
Okay. No problem after vacation. List after vacation on 14? 14/10. Maybe no interim order.
No interim.
I remember 55 lordship, something like that. And it is sort of vacation lordship. 60, 55, I remember.
Okay.
On 14 October.
Okay, list after petition, 14, 15, 15. No, okay, 14 also, okay, 14, 10. 14. Interim order, no.
Interim order.
It's there. It's interim order, by joints or cell, still. Don't worry about it. It's there, it will be explained. No problem. Next. Anything else? Yes, yes. Goswami.
The item number 31. The petition for postman. Charge sheet.
Caution.
Well,
I've been wanting to take admission, but it's not reaching.
No, understand.
All
my
time is come.
Too
After vacation.
My lord, that is all right, but there is one thing, my lord, scan copy was called for and that is received. But it doesn't include the CCTV footage of the informant's house, which was seized. That is important for the, that your lordship may direct and thereafter proceed for.
Mr. Bidding, council. Submits that doc scan TCR has been received. But document pertaining to CCTV footage of the
informant's house.
Informant's house.
The pen drive.
May not have been received and that the same is important for the adjudication. The scan TCR may be retained, shall be kept with the case report and the learned prosecution shall procure that document. From the court.
Yes, that is understandable.
From the court.
Yes.
The other relevant documents indicated above shall be procured from the learned court building. Scan document. It will be. It is an electronic.
No, actually, it is mentioned as pen drive in the
pen drive, but original pen drive it will be risky to get it because nowadays all are you.
Any document?
No, it will be. Nowadays, as you know, all this electronic inside the contents have been held to be documents.
Yes.
So you find out. He'll do it. You done it. Full. Don't worry.
Not sure.
And anything else? Take the date. You fix the date.
Immediately after the vacation, then, because it takes
16?
16.
16, 10.
Much of
31?
So basically, well, a small matter.
No, actually, you're not mentioning.
Yes, ma'am. So it will not cost money because similar order, similar.
Was there. And they have been waiting. CBI matter have to take. Actually, that also we have almost completed. Won't take so much time. And this supplementary, this thing, supplementary 63. So these three matters, how do we work it out, Mr. Rasegar? No, this, your matter is there. Yeah. Mr. Bora's matter and his matter. These three matters. What sequence should we take? Take it. No, I understand your temperament still. Your full understanding, good understanding. But well, you suggest whatever because I want to because they all have been these three matters I want to take up today. So
not much.
Your matter.
Yeah, will not take much time, man, because the similar order is already there, man.
Give me just 2 minutes toilet break.
Yes.
Short, concise. Good.
31.
Item number
31. Criminal petition 739, man. What happened, my lord, in this case, my lord? The several FIRs has been filed for the same cause of action, my lord. Then altogether 5 FIRs has been filed, my lord, for the same cause of action, my lord.
against the same person.
Against the same person, my lord. Same set of person, my lord. So, my lord, the first FIR was filed, that is the Annexer 1, my lord. Lordship kindly note it down. That is the Patharkanli PS case number 54/25 dated 21/2/2025, my lord.
First case is
That is the Annexer 1, my lord. In my index, lordship will find Annexer 1.
first case.
First case, my lord. That is Patharkanli PS case number 54/2025, my lord.
there is one more FIR in the Patharkandi on the next date, that is Patharkandi PS case number 50/25. Thereafter, my lord, Annex 3, Lordship will find FIR in Bukhaigaon, PS case number 31/25.
Gosaigaon.
Bukhaigaon.
Roger.
Then
30,
Lordship will- 31.
25.
31/25. Then, my lord, FIR at Kokrajhar, Annex 4, my lord, PS case number 61/25. Then there's one more FIR, Borpeta PS case number 72/25. Now, already, my lord, the FIR, my lord, Bukhaigaon, Kokrajhar and Borpeta, that is 31, 61 and 72, already been amalgamated with the first FIR, that is Patharkandi.
Which has been FIR serial number.
Bukhaigaon, PS case number 31.
Patharkandi.
Then Kokrajhar, PS case number 61/25. And Borpeta PS case number 72/25. That's already been amalgamated with Patharkandi PS case number 54/25. That is the first one. By virtue of the order dated, my lord, that is page 53, my lord, order dated 18/6/2025.
Page 50.
3.
Order of the court.
Order of the court. Now, we have before your lordship, for amalgamation of the next one, my lord, that is the page 68, that is Thekiajuli PS case number 55 with Patharkandi PS case number 54. That is our pair. Thekiajuli PS case number 55/25 with Patharkandi PS case number 54/25. Okay, I understood. So investigation will be carried jointly, ma'am. This cause of action is the same, whereas all cause of action has apparently arose in Patharkandi, my lord. Admittedly, nothing is Thekiajuli, nowhere. So court has, in earlier order, has been transferred all the amalgamated all the cases with the first case, with that is the Patharkandi 54/25. So that's the only prayer, my lord. Already there is an order, my lord, to that effect regarding the other three.
Refer to any case laws. Do I have to refer?
In that order also, lordship, probably there are few, TT Anthony, lordship knows it.
Yeah.
And the Babu Bhai and the.
Have to go through. Kindly help me.
Yes, my lord. Yeah, I'll give you the copies also.
That's all. From your side. Oh, you can give me later also.
I have given the copy, man. Already 4 or 5 judgment, my lord.
From your side, this much.
This much, my lord. There already there is an order, similar order. And this case, my lord, informant has already appeared, my lord.
One of Gustami's cases also there.
Yes, one of Gustami's case.
But you said TT and Tony.
That is the leading case, my lord. Leading case.
Well, let me come to the other side. first trial hearing? You are appearing for the informant.
Yes, look, earlier by earlier order, this is it is already pointed out by senior. Three cases already amalgamated. Case number 5425. Regarding the present case, the informant is informant appeared. He has lost this affair on the basis of this affair because the informant is individually affected. And thereafter, by making some allegations, those are specific, making some specific allegations. The informant has lost the present affair. The present affair is lost through the Curiae police station. Curiae. So now, my lord, if this case has to be merged with Pathakandi PS. So my lord, the informant now has to appear from this Curiae to he has to go to Curiae, my lord.
Which is quite far.
So it will now depend on the informant how he can manage to appear before that court, my lord.
First we have to see whether the main thing is the subject matter.
Subject matter, yes.
Subject matter is different, of course, it's a different situation. If the subject matter makes out the case of amalgamation, then
the FIR page 70 it reflects that, my lord. May I reach?
Then the other principles have to be seen, convenience and backdrop of the case law. I have to see it again, forgotten. Likely forgotten.
One person whose son
against the university,
Against the university.
Vice Chancellor.
Vice Chancellor, my lord, they have appeared in the examination in Pathakandi. There is some allegation that there is some mismanagement in the Pathakandi while appearing in the examination. Whole cause of action in the Pathakandi, nothing had happened in the Curiae, though it was registered. And out of all the students, he is also one of the students. Already that part is taken care of in the parent FIR by the Curiae. There cannot be second FIR, Lordship knows the principle, unless until there is a different cause of action.
Otherwise, 161 statement.
Yeah, yes, otherwise 161, 161 will cover everything.
in the FIR, my lord, it reflects that cause of action is only not at Pathakandi. You will say, may I read, please?
I have to go, I have
Page 17. Page 70, the present.
Page 17.
Page 70, 70.
17.
Myself, Mukshed Ali, son of so-and-so. Address, is farmer by profession. My son S.K. Farid Ali is student of class 12 under USTN, University of Science and Technology, Meghalaya, and appearing in SS final exam. He was also undergoing coaching classes in USTM campus under aegis of Vision 50. USTM campus is at, my lord.
That is in Riboy. If it goes by, then it will go to Riboy in Meghalaya.
Project for entrance into medical and engineering colleges. I gave admission of my son at USTM with a dream of bright future of my son to study there. That, sir, the USTM authority, by inducing my son and many of his colleagues, trafficked them and enrolled them in CPS, in bracket Central Public School, Pathakandi, to appear the SS final examination there. As per information received from source, some public, it is learned that the CPS, Pathakandi, and USTM both works under the same foundation, that is education.
Yes, I've read that.
Yes.
The second part, 5 lakhs given.
5 lakhs in the name of
Guaranteed admission.
Guaranteed admission with guaranteed admission. My son in any.
There is no guarantee for anything.
Yes, just before this ongoing SS final examination, my son paid another 40,000 to the USTM authority. Thus, the head of USTM authority, so-and-so, has committed sitting criminal breach of trust to all the students, including my son. He has also committed forgery and violated the sanctity of examination by inducing them with a false promise of better marks in the ongoing SS examination. They are tried to win the prison with students. So, although they are admitted in Vision 50 here, later on, though they are admitted at Vision 50, of
which is also, my lord, under USTM. Later on for appearance in the 12th standard examination.
Yeah,
they
not
were taken
actually, my
there
lord, I am not denying anything at this stage, my lord. Our contention, if lordship goes by the page 29,
Amalgamation and investigation.
investigation, I am not only
That is
there,
your
the
contention.
contention, it has investigation should go, page 29, it says same thing, my lord. He is one of the student out of that 214 student, which is already been investigation is going on. Same cause of action. Page 29. So, question is, my lord, informant will come later on. If the subject matter is the same, my lord, it's not the prerogative of the informant, my lord.
177. Also.
Yes. So the first of all,
Earlier.
yes, the first FIR that should be taken into account, and it will go on, my lord. The investigation, rest of the all FIR, as the Arnav Goswami's case is very specific, that will be on just 161, 162. There cannot be multiple FIR for the same cause of action, unless there is a larger and bigger conspiracy.
So we have to determine that limited point.
That's a limited point, and
whether it is
already
the same matter.
same matter.
CD is also available.
So the second part, my lord, already, my lord, the rest of the case, the similar FIR, same. One girl has filed the FIR, that is, my lord, Gukhaingam PS case number 35, that already been amalgamated. Same. Already been amalgamated with the.
Country, but the thing is that, okay, fine, I'll look into it fully, with the help of the case law.
Yes.
But just one passing thought that we said, that all the coaching was undertaken at the USTM.
Yes.
Students were resident.
Yes, for appearance in the examination, they were taken to CPS.
So I will Assam have jurisdiction, just asking.
So,
You know, that
so
is,
on the
that
pretext
is,
that they
So whatever the allegation.
that is not the issue here, but still.
The Pathar country may have the some part of the allegation. Pathar country may have the jurisdiction, but not in the somewhere else. Either in the USTM or in the Pathar country.
Yeah, maybe.
Maybe, but not the rest of the
That is
case.
your contention. That if not Pathar country, then certainly not Dhekiajuli.
Certainly not.
That is your point.
That obviously, well, Dhekiajuli, there is no allegation also.
That is your point.
So
I've understood this much.
already, my lord, the similar order has been passed, my
I
lord,
will
in
see
this
that.
case. Similar order in that line already been passed, my lord.
That's why it seems that apart from this, also a little bit of sim, because similar order. So in a sense, you know, I cannot. But otherwise, this case would have necessitated looking into the law of territorial jurisdiction, right?
May I hand over the page? The CPS is otherwise debated. So
what is CPS?
The institute where this examination was held.
Central Public School, man.
Central
CPS.
Oh.
That is in Pathar country. The jurisdiction, otherwise, if we go by the prosecution's case, is in Pathar country. No, my learned senior.
Where the coaching took place.
Yes, sir. The students were there in Pathar country.
And these students, they are studying in UST, right?
They are studying in they are appearing in CPS, which is under the
UST.
UST.
And they were taking coaching from UST.
At CPS, my lord, under C.
Oh,
under
not in
not here in USTM campus.
not in the campus. They are not. They were not USTM students. Only coaching.
Coaching level. So it's a coaching center, madam.
Nice. Not USTM's. Not USTM students. You know, undergoing the in-house coaching. USTM Vision 50. This is a separate.
Yes.
Yes. Now I get. Now I get.
No, my learned senior particular already pointed out the law. As far as the law is concerned, there is no dispute on the law. If whether it is TT and then you have Babu or subsequently honor person. If the subject matter is the same, my lord, then all the affairs need to be investigated.
Because person will be very harassed.
Yes, ma'am. So in that regard, already a court of this honorable court has already decided to amalgamate 3 existing cases
At Pathar country.
at Pathar country. So if this case
Similarly, that Dhekiajuli also he must have attended a CSP.
Yes, CPS, madam. So if since Pathar country is already investigating the cases, madam, So and two other cases have already been amalgamated into Patharkandi. So if this case is also amalgamated with Patharkandi case, that would lead to a logical conclusion of the whole investigation. So if that is the prayer of analysis.
You have no objection. From the prosecution's point of view, their interest is effective investigation. So, and as far as the inconvenience part pointed out, that can be taken care of. So the informant doesn't have to appear everything. Only during his deposition. That's all.
My statement, those things have already been done.
The basic examination in chief, everything can also be done here, and you have to be paid expenses. Okay, I'll no time reserve it.
Okay, publish, publish.
So I want to accommodate the article. No. I'll leave that with that.
I'm deeply offended.
My lord, with just out of context, my lord. Sometimes we can see, my lord, the 5 FIRs can goes in different places, one by one, investigation going on. This person has been arrested somewhere in the Dekhiajuli, somewhere in the Kokrajhar. Nothing. No step by the state government to amalgamate, my lord. But sometimes what happens, 50 FIRs has been lodged in one day, and in the one day, all FIRs has been transferred to CID. Just, it has happened yesterday. 50 FIRs in one day, they have taken the decision. It's the irony of this country. That's
Deeply offended.
CBA. They have waited long enough. Otherwise, madam will be very angry on me. Because I have kept you waiting for a long time. No.
In fact, we are taking.
You have a right to get angry on me. All of us, in fact. Let's decide. Huh? It will take it.
Yes.
Can it
be another date?
after vacation? What kind of matter? Can you just?
Mobile is not hearing. Can you fix from 26 watch? Only 5 minutes of
I
hearing.
can, but I don't know what will be the situation. We are ready to stay till not in the court till 10 o'clock also. So, but court also can be extended little while, otherwise other
It
people
will
will
be
get irritated. I can fix it, but I don't know whether it will be possible to take. If you want me to take a chance, I'll fix it.
Yes.
So
I will.
report of
56 report not yet received. 57. Report not yet received. List on to issue fresh requisition. List on 26/9. Okay.
May I please? The other day, your lordship called for the
Yes.
case diary.
Let us pick up from where we left.
Yes, ma'am. Already your lordship heard.
Hearing is done actually.
Yes.
So we just have to complete, not summarize also, just conclude it from
Yes, sir.
that case diary.
Diary has been received, I suppose. ma'am.
Diary has been received. You see, copies of the charge sheet. Original case diary.
Yes, ma'am.
To preserve some goods, some inspection.
Records.
I can have a look, you can point out. Don't worry about the facts.
Only issue involved is that
There-
is the
there-
prefix.
out there.
Prefix products apparent.
Yeah, those
Ground
points.
is not required. Latest judgment, again, I got point judgment, just. So, in warrant matter, it is inbuilt there. Inherent power, inherent ground is already there.
It was important. Can you, this is the case diary. This is case diary, it's just relevant part because his primary contention is the notice issue.
Yes, madam.
So can you help me with that?
He was already in custody, so question of giving notice is not required.
Okay, no, that's okay, but
And I have already submitted the order sheet.
where the reason, after getting satisfied, the learned trial court has issued the warrant. And warrant itself contains the ground.
Production warrant. CBI and I, diaries are very voluminous. Used to it.
State, coming from state police. State again, 61 of the state police there. CBI.
Matters are very serious, no doubt about it. The only thing is that whatever the mandate of Honorable Supreme Court, we have to follow.
Yes, sir. That is the only issue.
And the mandate has been given for the principles which have been laid down. Very correct, actually, that the constitution provisions newly interpreted in that manner. Because the person has to know about his this thing. Of course, earlier the IOs were not trained, so they did not know. Now they're learning, giving SOPs, and then following it. That's all. Should not be much bothered about that. Trial is still there. Main thing is trial.
Trial is not yet started. Evidence is not yet complete. Already 2 years have gone. Mostly the application was filed on 5/12/2023.
And I'm perusing all, I'm flipping through all the marked areas, application for allowing arrest. A detailed application has been submitted before the court, giving grounds of arrest, no doubt. But the notice is about giving to the person.
Yes, the normal notice goes to the jailer, then he produces the person into court. Only after his production, he is arrested. And the arrest, grounds of arrest has to be given only when he is arrested in this case. This is apparently they have not done. That is the admitted fact. They have,
Without notice, he cannot be produced, jailers. When production warrant is there, without notice to the jailer, he cannot produce.
now the only question is that whether the grounds of arrest is to be given or not. That is the only question.
The mail is there of 27/8/2025.
27A,
27/8/2025, the mail was issued from the court.
the production warrant.
It's production.
27A,
Regarding
27A,
the production warrant of accused person before the honorable court, CBI case number Swensu,
dated.
27/8/2025.
No, I'll check it. I'm just writing it.
I have this one copy. But I have only one copy. Probably I have given the, on the last occasion, I have furnished this copy to your lordship. And on compliance of that, we have produced before the mandate. Only one copy is there. On the last occasion, I have already submitted. And without notice, it is possibly they are in the custody of certain competent authority.
Nothing. That his contention is that notices were not given at all. Right?
No, grounds of arrest, when he is arrested in the zone arrested in this case,
That
then
was
they have to inform, give the grounds of arrest.
No, that was not given.
That was not given. That is
And-
my only concern.
and
And
for-
second contention is that because of the long delay. in
Yeah,
trial,
that's
sir.
true. And the other contention, both the notices, 47, 48, not.
Yes, sir.
not
That was not given.
That is his main contention, and if we go into merits, his contention is that this is, because of the delay.
Because of the long recursive. And if you're once, then I can provide the judgment also.
So I have
I think
Uh,
that will not be required, Lord.
This, how long he has been in?
Almost for 2 years. Since in this particular case, he is shown arrested on
2 years.
5/12/2023, my lord.
And you had said about the trial, I forgot, I must have written it down, note will be inside. Yeah, and how many witnesses have been examined? So,
No, appearance is not yet complete, my lord.
When the appearance is not yet complete, how?
The case is fixed on next
It is
23rd. my
the
lord.
delay on the part of the prosecution.
anyway, so that is, and Madam's contention on behalf of CBI is that this is a production, her contention,
Yes, ma'am.
as I have understood, production warrant. He was arrested on production, he was brought on production warrant and then arrested. And
So.
and the reason
grounds of
for
arrest
that
not-
were given, so that warrant itself constitutes notice.
Yes.
So that is not necessary and there is no information, procedure is informative.
Yes, my lord.
So on that ground, the person is not entitled to bail. Frankly speaking, we are
Yeah.
arguing, we have concentrated our arguments on both sides of matter on that point only.
Yes.
Merits, we have not really gone in, right? Merits,
It is only a technical issue.
we have not
Otherwise,
gone into
even if
merits,
The
really.
merit, it is a.
Merit might be, there
it
may
is
be
a
many
very
other
serious
things.
and heinous crime.
Many
There is
other-
an attack on the sovereignty of the
True.
country.
That's true.
And there is every likelihood if.
UAP
it
is there.
comes on bail.
UAP is there, UAP is,
No, in this particular, sir, it is not there.
it's not there.
Not there.
Because
In this case,
definitely,
also registered.
this will be a very legitimate grievance.
302 section is also.
This will be a very legitimate grievance.
395 is there.
No, very legitimate
24
grievance of a person.
45 was unsettled.
That, if 2 years somebody is in custody and trial has not started, obviously he will seek bail.
The trial, there is no fault of the prosecution. Rather, accused is not represented by their concerned lawyer. To that effect, the order is also
Yes.
there.
Whoever, if the
It is
fault,
delay on the part of the accused. They are not.
in that case, he may not be
A property
entitled to get a
represented.
benefit.
Yes,
Otherwise, if it is a mistake,
prosecution is always there.
if it
And
is
the-
sometimes it may not be a mistake of the
Because-
prosecution also.
Because of that, they
It
have
may be
to-
due to the court also sometimes. And even in
And
that
the,
case,
and the framing of charge, service of copy, it is the duty cast upon the trial court below also.
true, definitely.
Looking to the nature of the crime. It is not a fit case for granting any bail, otherwise the total investigation and the prosecution will get this case. They may not violate the condition if any imposed, even if suppose bail is granted and some conditions are being imposed. But then even behind the back, behind the curtain, they will do the conspiracy to vitiate the case.
So, actually, it's not a question of his fault or his fault, court's fault, everyone's fault. But in the present times, we have to accept this, that if bail is denied to someone, trial must be expedited. Trial must be.
Yes,
That
will
is
be there.
because otherwise that should not be only on paper, but actually in practice. You set up special days, you set up special court, do whatever, but it has to be, both things cannot exist.
But the duty cast upon the trial court below also.
Very much.
Day to day.
Very much, very much,
Prosecution
very-
is there, prosecution is there.
very much. In NI, I used to find that many people have been in jail for 7, 8 years. Also, trial is it's still 100 witnesses left to be examined. Yes. Anyway, our Shikhar, learned counsel, assisted by.
Even already judgment, these judgments are there of Sri Darshan's and
There are some great some.
accepted ground is not required that Pardiwala's case is also there.
Assisted by stop the learned counsel addresses further arguments. And Kumari, learned counsel, state retainer counsel, CBI, produces the case diary in original and reiterates our submission. that there is no procedural infirmity in the arrest of the present person, thereby entitling him to bail in terms of the recent case laws in this regard laid down by the Honorable Supreme Court. Arguments concluded, reserved. I'll no not time. Yes, reserved. I'll give it short before vacation because he's in jail. And whatever it is, it has to be decided quickly. Yes, sir. Time constraint is there. CDB retail. I'll give
It has come from the court to court.
Court to-
We, IU has not got it.
Okay.
Because of the honorable.
I've
court's
already
order.
seen, but I
Yes.
till
Only after-
passing the finalizing the order, I'll keep it. Awesome. I'll record your junior's name, assisted by junior counsel, assisted by your
Yes.
madams. Good name. Your good name? Good name.
And so.
And sure.
Awesome.
Your Lordship, as per your Lordship's order on 16/9 to 2025, the petitioner has does the submit upon the respondent number 2. On 18/9, 2025, he refused to take the notice as your Lordship. On 19/9, 2025, we have filed affidavit, your Lordship. Affidavit that on 19/9, affidavit was not part of the record.
Now it is part of the record.
Yes.
Let us come. Still. Two times it was attempted.
Yes. Already 6 months punishment was given by the government. One for he's in jail 4 months, 13 days, your Lordship. And there was delay of 295 days, your Lordship. On the your Lordship.
The done. Learned council, still nine it was called. Still. With regard to the interlocutory application. Steps of notice upon steps of efforts to notice respondent number 2 was not successful. And therefore, and considering the fact that the revision preferred, the revision petitioner was convicted under NI Act, is serving out the sentence of 6 months. Right order dated 16/9/25. The order dated 16/9/25. The applicant was permitted to resort to dusty service upon respondent number 2. Office note dated 29, this note. Indicated that affidavit regarding dusty service has been received and flagged as part of the report. It is also stated therein that paragraph 2 of the affidavit indicates that the notice was refused. Learned counsel has drawn my attention to the affidavit of compliance filed in this regard, and drawn my attention to para 2. It is stated and submitted that service through dusty was attempted twice, but the same was refused by the respondent. In the aforesaid facts and circumstances, the notice upon the respondent number 2 is deemed to be complete. We have to dispose of the interlocutory application, right, regarding suspension of sentence. In that case, same notice will do. Same notice will do. Do it. Should I appoint, second question is, should I appoint the amicus for this or not necessary? Not necessary. In the main hearing. Now I take up the delay condonation. The present interlocutory application, I 732, yes, filed under 5 of the Limitation Act, seeking delay condonation of delay of 295 days in preferring criminal revision against judgment and order dated 26/4/25, passed by the 2nd to I passed by the learned additional session judge number 1, Kamrup Metro Guwahati. Criminal appeal 38 of 22, upholding the judgment and order dated 15/3/22, passed by learned CJM Kamrup Metro Guwahati. Dash of the river, whereby the applicant slash petitioner was convicted under section 138 of NI Act 1881 and sentenced to undergo SI for 6 months and pay compensation of 3.7 lakhs within bracket ID SI for 2 months. The grounds for condonation have been mentioned in grounds have been mentioned. It stated in para 8 that the earlier counsel did not inform him about the appellate judgment holding his conviction and sentence, as a result of which police arrested him on 9/5/25 and since then was serving out the sentence. That his family members thereafter contacted learned counsel, obtained certified copy and then filed the appeal, filed a revision. And if it was a contested civil case, then something more than this would have been required, right? Some documents to support the reason for condonation. So delay is more. But since this is he's not participating, and the criminal matter, that is why liberal has to be taken. So the respondent complainant remains unrepresented due to the aforesaid reasons pertaining to notice. The quantum of delay was in the higher side. However, considering the four circumstances regarding non-appearance of the complainant and the fact that the petitioner is challenging his conviction and sentence in criminal law dash. I'm inclined to condone the delay. Accordingly, the delay of 295 days in preferring the criminal revision stands condoned, thereby allowing thereby allowing in disposing of IA number 732 of 32. Next. That is why I asked actually. Huh? No, we can take it as notice on this also. Otherwise, no purpose on this. IA number 732. 28. No, this 589. Highway 589. Heard account. Prosecution, not the. Did I record name? Not necessarily. For me, okay, maybe he's in the. Yes, challenging is your judgment and conviction rendered by a swatch of solution. Give me about bottom. Now come in the court list. For this to, make a mention tomorrow. It does not come in the court list. It was, I also did not notice. 7:30, it should have come actually. Because there's urgency in the matter. No, 5 I see. No, I fixed with the 2 IAs should have come. 1 have come. Make a mention to me. Make a mention. I'll pass the make a mention. What do you say? Actually got left out. Mention, make a mention. Take up. 2 will take up. 2.